on WPC 124417.
কি নাম?
রাখবেন।
অজুফা। অজুফা।
One two four four, huh? 1244.
1244.
Matter is remanded for test reconstruction. Next,
Item number 2, WPC 540217.
we are allowing the petition.
Item number 3, WPC 573918.
We are allowing the petition.
Item number 4, WPC 728021.
We are allowing the petition.
May I please alert? My lord, I am praying for listing of my lord, motion matter, my lord, tomorrow, my lord, kindly, my lord.
Why?
Lord, this matter is urgent, my lord.
When it was filed,
My lord, it is filed long back, my lord.
after vacation then.
My lord, some, my lord, he is, my lord, already arrested, my lord.
So
My lord, tomorrow, kindly, my lord.
when is a motion matter or?
Motion matter, my lord, motion matter. Kindly, my lord, my lord.
Yeah.
May I please, your lordship? My lord, I beg to mention for listing of a motion item tomorrow, my lord, some police atrocities against the police atrocities, my lord. Without any case, with the help of some, my lord, goons, the police is now trying to usurp my landed property, my lord, in the Karbi Anglong and Diffu, my lord. I have, my lord, informed all the higher police officials, but no rescue, my lord. Kindly, my lord, tomorrow, my lord. Oblige, my lord.
May I please, Lordship, I am praying for listing of a motion matter, Lordship, on Friday, Lordship. The
Wow,
person
wow.
is already taken in custody, Lordship, he is in custody.
My pleasure, Lordship. I beg to listing for matter. This is an this matter was filed on 16th of September, but it was registered on 19th of September. But this matter yet not been listed. So my beg to can be listed on before vacation.
May I please, your lordship? Lordship, I beg to mention an item for listing, an IE number 580 of 2021 in criminal appeal 06/2021.
I for what purpose?
Lordship, this matter pertains to conviction of the appellant under section 304B passed by the learned trial court, Lordship, Dhubri.
When he was convicted,
Uh, Lordship, 27/11/2020.
he was convicted in 27/11/2020. Huh?
I apologize, Lordship. This
I-
order was passed on 27/11/2020.
2020.
Yes, Lordship.
2 years before.
Yes, Lordship.
He won bail now.
Yes, Lordship.
What is the urgency? Medical case?
Lordship, urgency is there, Lordship.
Tell us what is the nature of urgency?
Lordship, the appellant is convicted, Lordship. So
Now, obviously, if he's convicted, he'll go to jail. Then what is the urgency?
Lordship, Lordship, I have a very limited knowledge in this matter, Lordship.
Who is going to argue?
Lordship, my senior will appear in this matter, Lordship. Lordship, may I pray for tomorrow or day after tomorrow, as per the convenience of this chief Lordship?
But you have to tell us what is the urgency, because we are not going to take up unless it is urgent. Only 3 days left last before the puja, so we will not take up unless it is urgent. You have to tell us what is the urgency. You can come after 5 minutes. You can ask your senior, ask him what is the urgency, tell us. You should know also,
Yes, Lordship.
isn't it?
Yes, Lordship.
Because unless it is urgent, he can come out after vacation also. If it is urgent, then you must tell us. And you must tell us what is the urgency. But if you say, no, my senior will tell us, then let senior mention. We don't. But we want to know what is the urgency.
Yes,
Is
Lordship.
it okay?
Yes, Lordship.
You will make a mention after 5 minutes, what?
Yes, Lordship, after 2 minutes.
After 2 minutes, okay.
Daily list for motion, item number 1.
Please, your lordship.
Aksar Ali,
Aksar Ali lordship, this person was declared Indian in the year 2016 lordship by the tribunal, and the same tribunal again summoned him to the court and started another proceeding. So the petition for res judicata was filed and that was rejected, and the case is fixed at the stage of
listen, Mr. Sharma, if he once declared Indian,
Let the record come, Lordship.
but in the meantime, let him not proceed. Once Indian, why should you? again-
But in the petition, Lordship, there was no fit perception mentioned in the petition, Lordship. So
Sorry, no,
regarding
no, what?
regarding fit perception, Lordship, regarding apprehension, Lordship, for.
No, question of apprehension doesn't matter. If you are Indian, you
No, I have
are Indian. If you
appeared,
are
Lordship, I
foreigner,
have
you are
appeared.
foreigner.
Just let the records come, Lordship.
Yes, but then question of threat perception does not arise. If
I
you
have
have been declared an Indian earlier, then he is an Indian.
I
So
have
you
submitted
cannot
the
be-
judgment also, lordship.
Let us see your earlier judgment. Let us see.
Earlier judgment is page 26, lordship, page 26,
Page 26.
lordship. Page 26. Page 26, this is the earlier
Aksar
judgment.
Ali.
Yes,
Ahmed
lordship.
Ali.
Askar Ali.
What is the opinion?
This is
Aksar Ali
the,
said
this is the earlier
is
opinion,
not. And
and
the
now-
present and that.
and in the present case, lordship, page 23 maybe page
23.
21, lordship. I'm sorry, lordship. 21. This is the notice in the,
Aksar Ali, son of
New
Ahmed
case.
Ali.
yes, and the same tribunal, lordship.
Kakahaguri, Bhing.
Yes, lordship.
Appears to be saying, okay, we'll call for hard, Mr.
Yeah, do see.
J.R. Hussain Ali, counsel for the petition, issue notice about 4 weeks. Mr. Sharma, you accept notice on behalf of whom?
I am on behalf of respondent number 2,
2,
2 and 6, Lordship.
2 and 6.
I'm for 5, madam.
5. 2, 6, 5. 1, Union, Devi.
Miss L. Devi was there,
L.
but.
Devi, Union,
Yes.
and Election Commission,
A Bhuya,
A. Bhuya. State Coordinator,
state code LDB.
L. Devi. Deputy Commissioner,
You
Madam,
done.
5.
Bhuya. Okay.
Yes.
Call for the records. In view of the submission made by Mr.
Yeah, do see.
J. Hussain, Lana counsel for the petitioner, that the petitioner had been earlier declared to be an Indian. White opinions dated 3/8/2016 passed by Foreigners Tribunal number 5 Nogong, Bhing, in FT case number 762/2015, arising out of reference case number 578/2011. However, in spite of the petitioner being declared in Indian, he has been again proceeded before the foreigners tribunal number 5 by the same foreigners tribunal.
Same foreign tribunal
which
by the
issued
attachment.
a-
my lord.
a notice upon the petitioner. And upon receipt of notice, the petitioner appeared for tribunal submitting that the second proceeding will not lie in view of the applicability of res judicata in a proceeding before a foreigners tribunal. However, the learned tribunal has not accepted the said plea and is proceeding with the matter and has fixed when
Your lordship, it was fixed on 9 last.
9, huh?
9 of September, it was fixed. The new date I have not got now.
And proceeded, huh? We have perused the earlier order, opinion dated. Page, opinion dated, page 20. 25, opinion dated 3/8/2016, in which the person proceeded has been recorded as page 26. MD Asghar Ali, son of Ahed Ali, village Kataguri, PS Dhin. In the present proceeding, in the proceeding which is challenged before this court,
Page
the name
21.
of the proceeding has been recorded as
Asghar Ali, son of Ahed Ali,
Asghar Ali, son of Ahed Ali,
village Kataguri,
village Kataguri,
PS Dhin.
PS Dhin, district Nagaon. Since the identities of the proceedings appear to be same, and in view of the specific plea taken by the petitioner that he is the same person who was proceeded earlier, the matter would be required to be examined. Accordingly, we have called for record. Consequently, there will be no further proceeding in the FT case number 4082 of 2017 before the said tribunal number 5.
Your lordship, record of both the cases may be called for. The earlier one and
Stop. For the earlier record, earlier LCR in this, the LCR in respect to the earlier opinion rendered in FT case number 762 of 2015 by the foreigners tribunal number 5 Nagaon Dhin may be also requisition. Please subtract.
obliged, lordship.
Yes.
Item number 2,
Shahida,
My lord.
what happened?
My lord, here in this case, my lord, she, after receiving notice, she appeared. She admittedly, my lord, after filing WS, she missed the 3 dates, my lord. One date, there was a heavy rain, my lord, he used to come from remote village, could not come, my lord, but advocate takes steps, my lord. Then, my lord, the second date, my lord, there was in this July month, Morigao district was heavily affected by the flood, my lord, she could not come. The advocates take steps. Then, my lord, in third date, she could not come because she was ailing, and advocate took steps, my lord. My lord, last date, my lord, the tribunal has rejected the petition and for want of medical documents, and ultimately proceeded to pass order without evidence. Lordship may kindly have a look at page 58, the input opinion. And Lordship may have a look at the paragraph, page 59, the relevant portion.
Yes, Mr.
Yes,
Sharma,
let
he
the
called
records
for-
come, Lord.
Mr. Lanakang for issue notice renewable 4 weeks. Same, Mr. Accept notice on behalf of same, huh? Union Devi, Assam,
Three,
Sharma, 3
I'm open.
Das,
I am for 2 and
SP, 2 and 4.
2 and 4.
was Sharma. Election Commission,
Yeah.
A Bhuya. State Coordinator, NRC, you are for both union and the state. They be for 1 and 6. Call for the records.
My lord, interim protection, my lord. necessary.
Saida Khatun,
My lord.
You require protection.
my lord, yes.
What kind of protection?
My lord, she may not be arrested and detained, my lord.
Not yet arrested.
Not yet
You
arrested.
have been submitted at the bar that the detainee Srimati
Sohida Khatun alias Sohida Begum.
Srimati Sohida Khan Begum.
Sohida Khatun alias Sohida Begum.
In your petition, what is it? Sohida Khatun alias Sohida Begum, wife, daughter of Abdul Razak alias A. Razak, wife of Kismat Ali, resident of Pali Harmon Farm, just has not been detained on the strength of the impugn final order impugn order dated impugn opinion dated 18/8/2022 passed by the learned FT in the second Morigaon in FTC 490/12. If that is so, he may not be arrested and be allowed to remain on bail, subject to punishing a bond of so 5,000 rupees security like amount before
My lord,
and
SPB,
before
SPB,
SP border.
SPB border Morigo.
Along with biometrics.
So, Diametrics, Iris.
Deep lovely.
For admission, item number 3.
No development as yet, my lord. No development.
This is Nya matter, my lord. This is still pending in the Supreme Court, my lord.
Oh, I see. It has been
That is
submitted,
after 3 months. my lord.
it has been submitted that the matter is still pending. The connected matter is still pending to Honorable Supreme Court. And I can only praise that the matter will be listed after 3 months. Okay. Well, likhna Mr. Das, Learned Senate Council, the NI, assisted by Ms.
So PK Darji,
PK
Darji,
Darji. Also Mr.
P. Boran.
P. Bora for the respondent. no?
For orders, item number 4.
May I please, your honor? My lord, in this case, I have received the paper book, my lord. My lord. My lord, I have received the paper book, my lord. So for my lord, service of respondent number 2, my lord. There was the order from this honorable court, my lord, to send it to officer in charge, my lord, concerned. And accordingly, I have seen the report also. Officer in charge has handed over the notice, my lord. I see. So I pray it to my lord for
Okay.
listing the hearing, my lord.
You have received the paper book.
Yes, my lord.
What
Paper
about
book
you?
is it?
Okay.
My lord, in while rejecting our prayer of bail, my lord, there is a order to outcome hearing of this case, my lord. So I request your lordship to fix it in November, my lord. For hearing.
Okay. And Mr.
Jiuddin, lordship.
Giyasuddin,
Yes, ma'am.
Learned Council for the appellant. Also Ms.
And
Bo-
thus,
Huh?
and thus.
Nandita Das, Learned Additional PP. Paper book has been prepared. Council have received the same. It has been submitted also that notice has been served upon respondent number 2. You have seen the note, police has said,
Yes, my lord. In Assam is with photo also, my lord.
here in this,
Yes, in IA, my lord.
in I.
There's a note in the IA. I have seen.
Who is this informant?
Sirajuddin, my lord.
And you have been convicted of what?
Yes, my lord.
Life. Huh?
And our bail petition also rejected, my lord. There is a prayer for early hearing.
And who is this informant?
My lord, Sirajuddin is the brother of the, my lord, deceased.
Brother of the deceased.
Yes.
Are you related to the deceased? No.
No, no.
Okay.
They have
Deceased,
some
how old was the deceased?
my lord. He
What is
was-
the name of the deceased?
This is name, my lord.
Yes, Sudhin.
Dr. Rajendra sir,
Gyasuddin, my lord.
49.
Yes, Sudhin, huh?
Yes.
35-year male body.
Correct.
Was he married? Do you have any idea?
He was married, my lord.
He was married.
Yes.
If he's married, the wife will get some compensation. His order, his the court
Perhaps there
passing
is
order.
something.
His the court passing order for regarding
That
compensation.
is-
His wife, my lord, on the basis of, my lord, eyewitness. His wife, my lord.
Wife was an eyewitness.
Yes. But my lord, other accused are, my lord, acquitted, my lord, from the same set of, my lord,
Okay,
allegation.
we'll examine.
However, my lord, my, IA already rejected, my lord.
Compensation is not granted,
No,
nothing.
there is no order.
Anyone. While going through the, only go on, this in the IA, as per the note, as per the report submitted by the Dabaka police station, officer
Yes.
in charge of Dabaka police station. It appears that notice had been served upon respondent number 2, the informant, on sometime in which year, which date, no date. You have a copy of that, received on WhatsApp on 18/8/2021, sometime in August
Yes.
2021.
21.
However, no one has entered appearance on behalf of respondent number 2. From the perusal of the impugned judgment, it appears that the informant is the brother of the deceased Gyasuddin.
Yes.
The said Gyasuddin was about 35-year-old and had a family. And child also, children also, huh?
My lord,
Only wife.
no idea about child, my lord.
Okay, had a family. And the wife of the deceased also was a prosecution witness, being PW,
PW1.
PW1. No, PW2 is Asia Begum.
Yes, my lord. Her name is
Ah.
Asia Begum. In my synopsis, I have stated, my lord.
Okay, Asia Begum. Full stop, next paragraph. We have noted from the judgment that the learned trial court had not passed any order regarding payment of compensation to the dependents of the deceased. We are of the view that payment compensation to the dependents of the victim would be required to be considered even at this appellate stage.
Because fine amount will be 10,000 rupees.
10,000 is fine. Under the circumstances, during the pendency of this appeal, we will direct the state legal service, what is this, which district?
District is my lord Hujai.
Hojai district?
Yes, earlier it was Nagaland.
Okay, now I'll let you know. The Hojai, and the Hojai District Legal Service Authority will make an inquiry as regards the dependents of the deceased, Ghiyasuddin. Is there is no reference to any other relatives of the deceased except for the wife, namely Asia Begum, who testified in the trial as PW2. So that appropriate order for payment of compensation under section 357A
Yes.
CRPC can be passed on receipt of such report from the District Legal Service Authority, Hojai District Legal Service Authority. Accordingly, let the Hojai District Legal Service Authority make an inquiry as regards the dependents of the victim Ghiyasuddin and submit a report before this court. List the matter after a month. Copy of this order may be furnished to the member secretary, Assam State Legal Service Authority, to intimate and who shall intimate the Hojai District Legal Secretary, the Secretary of the Hojai District Legal Service Authority to be renewful in terms of the bus today. List after 1 month.
1511.
List after 11 in chronological order.
Yes. After 1 month.
After 1 month.
Okay.
Most of it.
Item number 5.
Yes, yes.
On behalf of S. Gautakur.
Hmm?
S. Gautakur, Lordship. This matter,
What do you want?
Lordship, this matter may be fixed for final hearing.
Okay. Have you got the paper book? Have you got the paper book?
Yes,
Paper
Lordship.
book,
Yes,
paper
Lordship.
book. Huh?
Lordship,
You have got?
I have to ask from my senior.
You have to ask. You have a big file. Just check up.
Yes, Lordship, we have received.
You have also got paper book. The matter is ready. It has been submitted. Mister, what is your name, Mister?
SK Chakma, Lordship.
SK?
SK Chakma on behalf
SK
of
Chakma.
S. Gautakur.
Assisting Mr. S. Borthakur.
Yes.
For the appellant. Also Ms. Nandita Das, APP. It has been submitted that the matter is ready for hearing. Accordingly, list is for hearing. After the
Lordship,
yes.
whether informant is
Yes, yes. Who is the informant?
informant
Foxo.
Saleha Khatun.
Foxo. The mother. Who is the informant? Who is the person informant? Saleha Khatun.
Sister, Lordship.
She along with her younger sister in the house.
Lordship, I will inform my senior.
Huh?
I will inform my senior.
What inform you take without fail?
Lordship.
But yes,
Yeah.
B. Bhuya was there,
Applicant.
applicant.
I was asked.
How this IA, the informant was not heard or what?
I is allowed, perhaps he is on bail.
Correct?
Informant was
Not heard or what?
not heard perhaps. No, this was on August
No,
2022.
J. Das, Learned Counsel for Respondent was there. No, no. Yes. Which was the informant? It was heard without hearing the informant. Hmm?
The judgment was of, I think, 22 only.
Correct. But then, yes, we remember it was, we had allowed the bail,
Huh.
but then informant was not heard.
The judgment was the district officer. Informant have to be heard.
Hmm.
May we pick before this. That's an order sheet. In Supreme Court order, Supreme Court judgment is. Yes.
Informant was not heard.
COVID and says.
You take steps in a main case, we'll see.
Perhaps his bail order is before the judgment and it was not heard. Otherwise, in the judgment, it is said right from the investigation to the appellate court. There has to be heard in each and every stage.
Correct, correct.
But happened.
Lucky.
Lucky, they are on bail.
And the appellant shall take steps for service upon the informant, respond number 2 without fail. Office note indicates that the petitioner has not taken steps for issuance of notice.
It was informed by.
The appellant shall take steps for service of notice upon the informant. Informant is respondent here, no? Yes, informant, informant respondent without fail.
Respondent is not impleted.
This implemented in the main, yes. Informant herself is your minor.
No.
Oh, treated here. Oh. Informant, Miss Saleha Khatun. You have not taken steps.
My lord, I have, as per my, I am appearing on behalf of Mr. S. Bhattakur. As per my instructions, the steps have been taken.
No, the office note indicates otherwise. You take steps.
Okay, my lord, I'll do that immediately.
Yes, next.
Item number 6.
I'm obliged to.
Even this is a POXO matter. And the
Already my steps taken and notice to our information notice already been served by the government. But for this.
How did you land up in jail? Bola Shankar. There was also Shankar. also.
Yes, he knows a
Bola and
person in jail.
It has been submitted by Mr. Ella Majumdar and a council for the applicant date of material ready for hearing, this accordingly for hearing.
Obliged. Item number 8.
8 paper book is not ready, LCR is here.
May I please your lordship?
Yes.
Lordship, LCR already received lordship and lordship at this stage lordship may direct the registry to prepare paper.
Since the LCR has been received, let the paper book be prepared. This thereafter. Next,
Item number 9.
9 lordship, I
Mahesh.
appear on behalf of A. Ahmed lordship, amicus curiae.
LCR perhaps is not here.
We have not received paper book yet lordship.
LCR is yet to be received. I believe.
Lordship, LCR also not received.
Ahmed.
Lordship,
A. Ahmed. You are A. Ahmed.
no lordship, I on behalf of A. Ahmed lordship.
Oh. You are representing A. Ahmed.
Lordship.
You are in the same chamber or what?
Lordship, same chamber lordship.
You have Wakalanama holder of your Ahmed, no? You are authorized.
Orally.
He authorized.
Already authorized.
Orally.
In the morning lordship, due to his some difficulties lordship, so he
What
instructed
is
me
your
to
name?
appear
What is
this
your
way.
name?
Ayu Chaudhary lordship,
Ayub Chaudhary.
lordship.
Mentioning on behalf of Mr. A. Ahmed. Praise for submits that reports have not yet been received. Await service, await LCR. Await receipt of LCR. Who is the court? Who is the session? Which court is that?
Maheshwaram Nanda. Yes.
Peaceful.
Behind.
Registry to seek a report from the Court of Additional Sessions as FTC Sonipur about the furnishing of report,
Punishing of the LCR.
sorry, furnishing of the LCR. This up to vacation?
Item number 10.
Obliged.
Can also.
Urun Tanti,
Yes, LCR is not here.
they say not there.
Rakesh Sharma is the amicus. I know him. I can tell him. Perhaps he missed it.
What happened? He is there. Rakesh Sharma.
He comes otherwise. Today he
comes
must,
available. Today.
might have missed.
Yes.
LCR is
Name
not
of
here.
has been updated. His name is shown, no, in the poll list?
His name is shown.
Very well.
I'll tell.
Okay. Report and when was the order passed? This on March 22, by which court? Sessions Vishwanath. Records, lower court records have not yet been received. Registry to seek a report from the additional session judge FTC Vishwanath regarding submission of the records. This up to the month.
Item number 11.
Dr. B. N. Gogoi is not here. IA is pending. And I'm yet to file my objection.
No one is present for the applicant. Ms. Jahan, praise for
1 week's time.
1 week time to file objection to the application. This accordingly.
Supplementary list for orders. Item number 12.
My objection is on record.
Where the lordship's my lord,
I for what?
I am for granting bail, my lord.
Suspension.
My lord, in
You
this
have been
case, I have
convicted under which
punishment under 302 and 120B, but 120B is not applicable.
302. You are the only accused.
The only accused, my lord. Now, my lord,
Eyewitness.
no eyewitness, my lord. That is, my lord, kindly allow me some time. Actually, this is a clear case of acquittal. No eyewitness and nothing was recovered at the instance of accused person, and the mobile number which was used before killing of the deceased, that mobile number belongs to whom, that was not proved. And the person concerned from the mobile company came, they said that we do not know in which names the present mobile numbers exist. So at all, there is first thing, my lord, the PW1 is Shamsul Ali, the own brother of the deceased, my lord.
In fact,
It
there
is
are
actually,
four
my lord,
accused.
moral conviction.
There are-
Actually, moral conviction, my lord. Let me submit first.
No, I'm just telling about accused. There were 4 accused.
4 accused. One
Yes.
person was killed by police. The main person who killed Abdul Khalik, he was encountered in presence of 50 police personnel, my lord. They say that the Abdul Khalik tried to escape from the custody of police, my lord. His hands was tied up from the backside. 50 armed police, including additional SP, SDPO, circle officer, and OC were present. So that was extrajudicial killing. For that person, reason we have already filed a case, my lord, against the police. Second thing is, my lord, Shamsul Ali, who is the informant, come brother of the deceased, my lord, he said that we suspect this Safiur Rahman and others. And this, my lord, he never told that reason of suspicion that Safiur Rahman has an illicit relationship with the wife of deceased Yad Ali. But he says that no case is filed, nowhere there is a village mail also. Second thing, my lord, Akbar Hussain, he supports our case. He is Akbar Hussain. He does not say anything against any of the accused person. Third, my lord, third week, Abdul Malik, he says nothing against the person. He says nothing about the backside injury, and which was reflected in the postmortem report. Postmortem report does not say any injury in the backside. He says we saw backside injury in the person of deceased Yad Ali. Then, my lord, Binoy Kumar Khaklari, he is the PW1, he does not know. He is the neighboring person near whose house, my lord, the incident took place. He says we have not seen that person. And then, my lord, 6 is Santosh Musari. He also does not support the prosecution case. 7 is Hitesh Das, the same thing, my lord. The SDPO was the witness, a confessional statement, my lord. Here, one thing is this, my lord. Confessional statement was recorded in the police station. Very strange matter, my lord. In the police station, it was recorded by the executive magistrate. Whereas hardly 100 meters of SDGM court, additional decisions, because there are 4 or 5 judicial magistrates. And Lordship is aware, confessional statement before executive magistrate is not acceptable. And moreover, that statement was recorded in the police station before police personnel himself. So totally imperfect information only to get rid of the consequences of killing Abdul Khalik in extrajudicial killing. Then, my lord, will say PW 8 is Lekha Ravidas. He says nothing. He was only the person who pitches the dead body. So he does not know. 9 is Mominul Islam. He has not supported the prosecution case. 10, my lord, 10 is one Khan. He does not support. He is the owner of a truck. He says that rupees 50,000 was taken by Safiur Rahman from me in exchange of keeping his motorcycle. And Rasul Khan, my lord, PW 11, he does not say anything about the implication of the accused person. And 12 is Rashid Ahmad. He is the seizure witness. He does not do anything. 13 is Pratul Rai. He is the constable of police at Bujdi police station. 14, Bulbul Rahman Talukdar. He is seizure witness. He does not say anything. Then 15 is Johirul Islam. He also does not support the prosecution case. 16 is Abu Shama Sarkar. He also does not support the prosecution witness. He further says, we have not seen any blood-stained clothes or dowels. And IO did not send those things for the forensic examination. Qadam Ali, he is a seizure witness. Saidul Islam, he said police did not record his statement, but he was examined by court. Even then, he did not support the prosecution case, my lord. Then PW 19 is the Dilchand Ahmed. He also does not support the prosecution case. Now 20 is Ansar Ahmed. He is the Caesar witness, my lord. Mohibul Haq, he says that Abdul Khalek was killed by police when he was in police custody. The Abdul Khalek was, it is the allegation that Abdul Khalek killed Iyad Ali. Actual thing, my lord, I have been told by my client that Iyad Ali was the home guard in the court of learned.
Oh, what your client says.
They say, yes, now we are on record. So it is a moral conviction.
Oh, what is it? Abdul Khalek?
Abdul
PW?
Khalek is killed by police.
No, you said what?
Mohibul Haq says that Abdul Khalek was killed by police in an encounter.
Who says?
Abdul Khalek, PW 21.
PW 21.
Sorry, Mohibul Haq, PW 21. Mohibul Haq says,
PW 21.
yes. Then Omar Mondal,
Yes, PW 21.
yes. Not a single witness, my lord.
PW 21. PW 21, reference is in the judgment.
Judgment lordship may,
You are reading so many things, we don't know from where you are reading.
no,
Because
we have
don't
the witnesses, my lord. I
You
must,
have the records have been requisitioned over in this case.
these are the
Yes.
witnesses.
Or records are there.
Records
My lord,
are
I am
not,
giving this copy of the witnesses.
records are not here.
But you have got the certificate copies and the copies, kindly see this. I am saying on the basis of record, man.
That's
There
what
is
want to-
nothing at all against
We
me.
want to see. Evidence of PW?
PW 21 Mohibul Haq, my lord.
21.
There are other witnesses. I have also given the important witnesses, my lord. Important
21,
witnesses.
15, 17, 24, 25, 26, 28, 31. You are not giving the 21, you are referring to that, what is it, 21? 21,
IO is my lord, PW 32.
you are referring to some witness saying
Yes.
that he, that police has killed, what is it? Who had given the statement? 21,
21 Mohibul Haq,
Mohibul Haq.
yes.
Close, I came to know that one of the accused, namely Abdul Khalek, was killed in an encounter. No, you have been accused of killing whom?
No, nobody has,
No, you have been convicted of 302.
yes,
Of killing whom?
killing Iyad Ali.
Huh?
Iyad Ali,
Iyad Ali.
yes.
By employing contract killers. So Khalek was a contract killer.
You are, according to the prosecution, he is a contract killer. Contractor.
That may be, my lord, but what is evidence against me? Not a single witness said that I have any indication.
Yes.
Only
Says
circumstances.
no witness. What do you say? What is the
No,
evidence against
the
him?
only evidence that I saw here is the call detail reports of all the
CCS.
SIM cards that were seized
From him?
from him. There were 3 SIM cards from the accused, that is the Kondokar.
Was any conversation also recorded?
Conversations were there. And from the, they had also examined the nodal officer of the particular phone company.
Yes.
And the call, the detail showed that the wife, the other convict, in fact, the wife of the deceased was also convicted. She was the kingpin and she had number of conversation with the applicant. And then applicant spoke to the contract killers. And then applicant brought those contract killers from across the river.
My lord, one
have a
reply
look
to
at
my
the
letter
record?
saying,
We will see the record and.
the nodal officer of mobile company came, they let my learned friend show that these mobiles belong to us.
In fact,
Not
this-
a single witness saying, my lord, that those mobiles belong to
Requisition
me.
the record. We'll requisition the record.
That's it.
When you are convicted, by which order?
My lord, conviction is on 7/7/22, but we are in custody since more than 1 year because from after arrest, we are not granted bail.
Anyway, we'll see that, we want to have a look in the record, because you are convicted, it's not a normal bail. Bail, two types of bail. One, bail during investigation. Now investigation is over, trial is over, the trial court has convicted you, we'll examine that. We are not saying, we are yet to give a final approval, but there is a conviction from a trial court. So we'll see the record.
My lord, my only prayer, kindly bear with me. First thing, statement was recorded under 164 by executive magistrate. That is totally unacceptable.
That I'm not relying on.
Secondly, my lord, no perfect investigation was
We'll see that.
conducted.
Let
Evidence
us-
report is not there.
Give us some
mobile-
opportunity to examine the records.
There may be mobile
From which
conversation, but
district?
those mobiles do not belong to me, my lord.
From which district?
Chirang.
Chirang. Okay, Chirang is not very far off.
Not far away, my lord. Hardly 150.
So after vacation, after Durga Puja.
But I expected that I would be granted bail, my lord. For no
You will be
legal reason.
granted bail the moment you are satisfied after seeing the records. You want to see the
The
records.
record was earlier called for, but
That's why we'll ask. We have the view that perusal of the records would be opposite to consider the bail application accordingly. Accordingly, in the main, that already order must have been passed for the record.
Yes, yes. LCR was called, admitted.
Accordingly,
Hmm.
let the, which is the court, concerned court, sessions. what?
additional session judge, Chirang at Bijli.
Disney may ensure sending of the LCR by next date. Director leave after vacation.
Immediately after vacation, kindly. I have-
311.
I have
Mr.
small
Mr.
sons and a wife. They are,
Mr.
I am the only earning member.
Yes, after vacation.
311. Item number 13 for orders.
Shibu Sarkar.
Oh, can I copy it? This came up yesterday, and Lordship wanted me to see the judgment and all, although I have not filed my objection. I've gone through I've gone through the-
Anything?
judgment. Yes, yes, there are so many things. He had relied on the dying declaration. In fact, dying
Oh.
declaration is subject to correction, was not relied on by the session
Oh,
judge.
the other evidence.
Other evidence, the daughter, this minor daughter of the victim,
Yes,
her statement is there.
I rely on two, my lord.
Let us see the minor daughter evidence.
My lord, kindly first see, my lord, page number 23, my lord. Of my appeal petition, page number 23. Para 18.
Foxo, no?
Para 18, my lord.
No, no, not Foxo. No, no, not Foxo. 302.
No, we'll not read page
Page 23
of what?
of my appeal petition, my lord. Criminal appeal, my lord.
Srimati Sushma Vishwas.
Yes, yes, my lord.
Deposed that she had stayed neighborhood house about what happened took place. While she was annoyed after hearing from the house, he came on to the house. Never came. They asked the accused to open the lock, and the accused came and opened the lock. After they entered the house, so he was burned and he was found sitting on the floor. When they saw Mama at the time, her parents burned. Then Mamani was taken to hospital. Who is this Sushma Vishwas?
My lord, neighbor, my lord, door neighbor.
Okay, very well. Why is that?
Jack,
Why is
my
that daughter?
Daughter, page number 24, PW 6.
Sriya Sarkar, daughter
Shreya
accused,
Sarkar.
who has been examined after testing a capable constant, has deposed that accused the father to whom she called Bapi, her mother, so and so, on the day while she was mother accused her assault her mother without any rhyme, reason, and asked her to bring money from Canada. Oh, you married to bring money from the wife, no?
He has already extracted 70,000 before,
70,000. Why
75,000.
you should go to market and work and earn your livelihood.
My lord, I am a
And-
medical representative, my lord.
And then you sell medicine and earn. Why you want to
Why should I
extract
demand,
money
my
from
lord? I
your
am a
wife?
medical representative, my lord. Why should I demand?
And the wife gives you free food, cooking,
And
you
my
can
lord-
engage a servant, how much they will charge you. Your wife does not charge you anything for cooking, washing your clothes.
My lord, my wife was.
And you want to
nobody worked on,
extract
my lord.
70,000
She
from
was
your
also-
wife.
She was also earning, my lord. She was also earning, my lord.
But your daughter says,
My lord,
Absolutely not.
my lord,
mother accused started assault
At
her
that
mother
time,
without
my
any
lord,
rhyme reason, asked her to bring money from her parental house.
what happened, my lord?
After
After
assaulting her mother, the accused pushed her into the bathroom. Thereafter, the accused again pulled her mother from the bathroom, brought out a matchbook from praying Thakur Thali. You are using God's
My lord, what happened actually, my lord, when
offering also
my
to
wife
burn
died, my
somebody
lord, she was taken to my
and
mother-in-law's
set
house,
her
my lord.
on fire.
She was tutored, my lord. She was tutored,
We'll
she was taken
examine-
to my lord.
we'll
Can you see, my lord, kind pharmacy inspection, my lord?
We'll examine whether she was tutored or not.
Page 19, my
We'll
lord.
call for the reports.
My lord, page 24, para 19, my lord.
Page 24,
Para
para
19, my lord. During the cross-examination, my lord, she had admitted that her house was about 15 meters away from the house of the accused. Accused was staying in their village for about 1 year until the date of the alleged incident. During that period, she did not notice any incident of quarreling between the accused and the deceased. When she reached the house of the accused, at that time, Tapas Majumdar and Sushila Majumdar were already found present in front of the house of the accused. When she reached the house of the accused, the gate had already been opened by the accused. On being asked, Mamuni Biswas, who was under flame, told her that she had been set fire on her by herself. See, my lord.
Nico, and Mr. Lanek counsel for the applicant.
And dying declaration also very clear, my lord.
It has been submitted that the conviction of the applicant was based on the dying declaration where she was yet categorically stated. Why is the dying declaration?
The
page?
dying declaration at page, my lord, page 30. Page 30 of my IA, my lord.
But not referred by the session judge, no?
Hmm?
Not referred by the session judge.
See, page
Page 29, my lord. Page 29 of IA 521. Can
in
you see
which
this,
she
my lord?
had stated based on the dying declaration of the deceased, who stated that at around 9:30 PM, fire somehow caught me while I was preparing food in the oven. Within court, page 29. I was brought to Nemkar Hospital. This would clearly indicate that it was a accidental, it was not a homicide. It was not a homicide. Homicide of which the appellant has been accused of committing. It was an accidental. And accordingly, he may be allowed to go on bail during the pendency of the appeal by suspending the pendency. Next paragraph. On the other hand, Ms. Jahan Laner PP has submitted that Laner trial court has not really based the conviction of the appellant on the aforesaid statement. On the contrary, the minor daughter of the deceased and the appellant had categorically stated that her mother, the deceased, was subjected to assault, physical assault by her father, and in fact, it was the appellant who burned her mother. In this regard, has drawn attention to para 20 of the उसका पहले लिखो हाँ उसका before that. Mr. Rahman father and accordingly has drawn attention to the finding of the Lanet trial court in para 19 of the judgment, in which it has been mentioned that in which the Lanet trial court had discussed the evidence of one Srimati Sushma Biswas, who was examined as PW5 and never, who stated during the cross-examination that when she reached the house of the accused, the gate had already been opened by the accused, and when she reached the house of accused, she asked the deceased Mamani Biswas, who was under flame, who told her that she had been set on fire by herself. And when the other people present asked the accused as to how it happened, the accused told that he did not know. He did not know anything, though he was sleeping in the same room. On the other hand, it has been submitted by Ms. Jahan Laner, additional PP, that the Laner trial court, while convicting the appellant had relied heavily on the evidence of their minor daughter, Miss Priya Sriya Sarkar, who was examined as PW6, who stated that her mother was assaulted by the appellant father and thereafter pushed her into the bathroom, and again her mother was pulled out from the bathroom and thereafter set her mother on fire. And she also at a time was sitting on the bed and crying and pleading with the accused not to crying. She was crying and the accused asked her not to make the shout, otherwise he will also kill her, like the mother. Full stop. It happened also, the learned trial court also took into consideration the evidence of the said minor daughter, that after setting her mother on fire by means of a matchstick, the accused was playing with his mobile phone. And when the deceased was pleading for help, the accused threatened her that she would raise an alarm and he would also kill her like her mother. When her mother was engulfed with fire, she was moaning in pain. In the meantime, on hearing the shouting neighbors, on hearing the neighbors shouting and knocking the door, her father told the neighbors that nothing had happened and they should leave his house. Later, a neighbor Taposh came inside the room and saw her mother burning in flame, and her mother was taken to hospital. Next paragraph. We have gone to the judgment for the purpose of consideration of bail application. Considering the evidence of the said minor daughter, we are not inclined to grant bail or suspend the sentence by grant bail to the applicant by suspending the sentence. The submission advanced that the child was treated will be duly considered at the time of hearing. Application is dismissed. I-
Item number 14.
Shahjahan Alam.
May I please, your lordship? Your lordship,
What
it is
is
an
this?
higher
IFO
pardon
what?
for condemnation of delay, your lordship.
How many days?
For 1 day, your lordship.
1 day, yes. And Mr.
Should be condoned.
D. Hussain Lane ka, huh?
It's already delayed, it's condoned. Appeal to be registered.
No, there were some errors in the prayer portion, that's why it was.
Oh, acha,
Oh.
acha.
Reposed.
CJM.
Yes.
Oh, that Karimganj and all
Yes.
this. You have corrected it?
Yes, your lord.
Okay. The hard Mr. What is your name?
R.A. Majumdar, your lord.
RM?
R.A. Majumdar.
RA.
Yes, your lord.
And Mr. R.A. Mazumdar Lane counsel for the applicant, the same application filed for condemnation delay of 1 day. In filing the appeal, the said application not being seriously objected by Ms. Jahan Lane PP. We are inclined to allow this application. We also noted that we have not issued notice to respond number 2, the informant.
Condonation leave is actually the prerogative of the court.
Reason, considering the fact that it is only 1 day delay, we do not feel it necessary to hear the informant in this. Only that is allowed, delay condone. The connected appeal be listed after restraint.
Obliged.
Yeah,
Please, your lordship. Lordship, I was supposed to appear for item number 11 of the daily list, but when the matter was.
Ujjwal Kumar,
Yes,
did we
lordship,
pass any order?
Yes, I was supposed to file my objection
Okay.
and they were not there.
Yes, what do you want?
Lordship, when the matter was called, I was outside, Lordship.
Okay, now what do you want? Tell us.
Lordship, we have taken steps, so Lordship to fix this matter after the puja vacation.
The puja vacation.
Okay.
Okay, what is your name?
GR Sinha, Lordship.
Likho, हाँ, and Mr. G.R. Sinha Lane counsel for the applicant. This is a matter of the vacation. You have taken steps already?
Yes, Lordship.
Okay.
Obliged, Lordship.
Daily list over. Hearing list. Item number 4.
Yes, yes, you wanted to mention something.
My lord, I'm sorry. Well, she was actually not the assisting junior in that case. What has happened in this case? Alia IO was
No, some urgent something.
Yes, sir. IO was moved for bail, and basically it was moved on the period of detention. We did not have the deposition and the postmortem report and all. Now, it is a case of 304B convicted for 10 years. Now, when we go through the postmortem report, it says the death is result of asphyxia due to smothering and all. But if your lordship looks into the postmortem report, it's a 304B conviction. Your lordship will find that there is no any injuries showing that death has to be by asphyxia and all. And there are other, any day before the vacation, we'll take one chance. The person is in behind bars for last 2 years.
After vacation or before vacation?
For 2 years, he is in jail.
Before
But
vacation,
I think that your lord,
how many days are left before vacation, Mr.
Well,
Ford?
well, when we will be doing one case for all these days, then one will come as a complimentary.
My objection is also not there. We'll
The
also
objection
do-
is on the record.
Oh, acha, acha. I've already filed.
We'll take a chance, my lord. If it takes time, then we'll any day before vacation.
After.
Yes, ma'am. Then yes,
after-
on
after-
19th of October, my lord.
Immediately, it says.
Immediately,
20th.
you won't be ready, Mr. Kumar.
I'll leave it to you, Lord. 6 days are there, only working days in October, my lord. I think 19, 20, 21,
Yes.
and my lord, 26, 27, and 28.
IA. 20. 21.
21,
21. 21.
Friday.
Well, your lordship will recall, on the last occasion, I was referring to the deposition of PW3, the informant. Your lordship has seen in the FIR that 20 persons were named in the FIR. Then out of that, 16 are before your lordship as appellant, all convicted under section 302 for life imprisonment and 326. Now, so far the FIR is concerned, your lordship knows that it will not be the encyclopedia of all the facts which are required to be mentioned there. But when your lordship looks into the evidence of PWD 3, your lordship will find that the PWD
Is cattle theft? Cattle theft?
no, that border dispute in regard to Badam Ali between two groups, Sobul Mandal, my lord. That Ainal company.
Final company.
Yes, ma'am.
Company case.
Yes. Ma'am. But if your lordship looks into the evidence as a whole, I will not pick up one line from a particular deposition and try to impress upon your lordship. upon the-
Just a minute.
No. But then there was a the dispute that we want it to be done by a government mandal and all. Then what they did, since a INL company did the demarcation with the help of a mandal, all these PWs who are there, they took INL mandal and confined in the house near the ditch of one of the house of the deceased. Now INL company, as I have told, Mallory, is like a village, Gaubura. So when 3-4 villagers, he is quite respected in there, they came to know that our Gaubura has been confined by them. Then all the people came to rescue INL company. To that extent, my lord, your lordship may say that yes, there is a common object to rescue INL company from the classes of this prosecution witnesses. And what they came with lathis and all those which are available in the field and all. The witness of the deposition says that lathi, spear, dagger, and all those things. But your lordship will also take note that none of these weapons of assault were ever recovered or seized by the police or they were ever sent to forensic test and all. That is another aspect. So this free fight took place when they came there, because there was a, since I have pointed out to your lordship on the other day, that when there is a free fight, sudden fight, and when the PWs themselves are the persons who are the initial aggressors of causing injuries to INL company and all, then 149 will not be applicable. So we have to look for the overt act of each of the accused, or whether there are some common intentions shared by the some of the accused who were attributed that overt act. So with that objective in mind, my lord, I started my reading of the deposition of PW number 3. And your lordship will also take note while going through the division that although some of the
PW3 is now deceased informant.
this is informant. So your lordship will also take note that when your lordship goes to the deposition of the witnesses, they say some of the witnesses say that there are injuries seen on the body of INL company. But your lordship will, they have never given the correct genesis of the incident, that they are the persons who have caused the injury to INL company. But some of the prosecution witnesses have said, especially the woman whose husband have died, they have said that it was our villagers who had initially confined INL company, and that's how the fight started.
How many witnesses were
There are 16 prosecution witnesses and 16 appellant, and so far there are injured witnesses also. Now, when there is a previous enmity means in regard to the plot of land, your lordship knows that there will always be a tendency of the witnesses to implicate the persons who are whom they know. And out of the 300-400 persons, they have named only the 16 appellants only, and there is no explanation why they could not identify the other persons who were part of the mob, and all those explanations are also not there. And when your lordship goes to the evidence of PW number 3, your lordship will also notice that for the first time, he has tried to develop in the court. And I will point it out that these developments are there when he sees some of the reports which were not there when he initially recorded his deposition under section 161 CFPC. So your lordship will kindly take up the deposition of the witness number PW number 3 at page 14, and the original.
Okay, we'll take it up PW3.
Yes.
But who is this PW1?
PW1 is the doctor who examined the injured, and PWD number 2 is the doctor who conducted the postmortem report. So that's why I'm not reading it. When I will be reading it, PW number 3, who says that I am an injured witness, then I have to refer to the PW number 1. So I will be referring to those paragraphs, and immediately I will take your lordship to the injury reports if there is any. Original.
Lordship has already dictated the facts.
Okay, that's what I was thinking. That's what I'm going to. We'll just have a look. Then we'll understand.
All the witnesses Lordship has dictated.
Yeah, your lordship has detected the basic facts. Your lordship has not analyzed the evidence of PW number 3. So your lordship will kindly see the deposition of PW number 3 at page 14. And the original is also in English, but the handwriting, my lord, original is also English, so there were some typographical errors, so your lordship has to look into the original also at times.
So on the basis of PW3, what do you want to say?
Well, yes, your lordship will see how he says that the incident occurs. The first genesis of the incident, how he described, my lord. Your lordship will see. I am the first informant. Occurrence took place in the year 2003. Your lordship, while dictating the order, has taken note that it was 16/2/2003. So nearly 2 decades have passed, my lord. It was Sunday at about 8:30 a.m. I was at home. So he says that at 8:30 a.m. he was at home, because why your lordship has to take note as to how the incident has started as narrated by PW3, because when I will be referring to PW number 4, the occurrence is again from a different angle. So Ainal Haq came to my house. He is one of the accused. This Ainal Haq, my lord, who is referred here by PW3, is that Ainal company who is since deceased, my lord. This Ainal Haq. Ainal Haq is the same person, Ainal company who is since deceased. He was accompanied by Ajiju. So Ajiju was there when they went to the house of this PW number 3. But Ajiju was not is not a witness, nor he is an accused, and then there is no explanation why Ajiju was not been brought as a witness, my lord. I was called and taken to show the boundary line of the paddy field. I saw that the land where the badam groundnut crops were growing, boundary line called Ali was given. I did not accept the boundary line and told that I will accept only when government Latmadal measure the land and demarcate. So he does not say, this witness does not say that it was they who had initially confined Ainal company, and when people went to rescue Ainal company, this subsequent events took place. So his genesis of the information starts. He is, because if the because, my lord, if your lordship knows that if a witness is wholly reliable, then there is no problem. Even if there are minor embellishment, exaggeration and all, your lordship will
You
ignore.
are saying that he did not disclose the fact that Ainal company was already detained by this.
Yes.
But that is based on what evidence?
I'll come to those witnesses who have said that they had confined Ainal company in the house of, near the house of the deceased Rohijuddin in a ditch.
That woman?
Yes.
In the cross-examination?
Yes.
In
And
the
there are another 2 witnesses, I think.
2 witnesses in the cross-examination?
Yes. And when you suppress the actual genesis of the occurrence of the witness, you will not be wholly reliable. Because when a witness is wholly reliable, then there is no problem. Your lordship will ignore the minor exaggeration and the contradiction. If a witness is wholly unreliable, then also no problem. Your lordship will not believe that witness.
Yes, what is that?
No, I was telling him
so
to
I'll-
conclude within 1 hour or so because Lordship
not-
has already dictated.
Huh.
And I was just requesting him if you can finish in 1 hour or so because
Hmm.
otherwise if it takes days and days together, it will go after vacation again.
No, the Lioness Senior Counsel, he knows the art to squeeze in. But he also knows not to squeeze also. So what is the option you are taking? Squeeze in this, because you have already, we have how many
But your
pages?
lordship has given the
9 pages.
description of the facts.
Fact.
First.
So you please
Now I have
come to
to,
the.
now to analyze, I'll be.
For example, you said a PW3.
Yes.
He,
I'll
number
go
one,
point
he's
wise.
not. That will be nice.
Yes.
Then we
First,
can.
yes, I'll, so the first thing that you will not, you will notice, so far PW3 is concerned, that
He is
he
not
is,
disclosing that fact that Ainal company has been already detained by the party.
yes. And he is not giving the true genesis of the
true,
occurrence of the
he-
incident. Number one, your lordship will take.
Therefore, his
And
his
he
evidence
is,
not reliable.
And he is suppressing. And deliberately suppressing facts. And is not coming out with the true version of the occurrence.
Yes.
First is, my lord, he is, your lordship can, he is not giving a true genesis of the occurrence.
Yes, yes.
Second is, my lord, he is.
So he's not, he's suppressing, but therefore he is not reliable.
And and he is not giving the true version of the occurrence.
So that's how we
Therefore,
are.
he is wholly
Okay.
unreliable.
Now, PW3,
Okay.
we are
So,
there. Then next.
Then your lordship will see. The next line. He says, thereafter I was assaulted by Nurul, Sobur, Manik, Rasid, Ainan Mondal, Alauddin and Hussein, Nurul, Nur Jamal, Baten, Satar, Manik Bhuya, Ibrahim, Rostam, Rafiqul Ali, Elias, Sokra, Rajiju, get out me and assaulted. On the last occasion, I already pointed out that so far Sobur is concerned, there are two Soburs.
Sobur Mondal and Sobur Mullah.
Yes. I also said there are two Manik, but your lordship has said that in case of one, he has said simply Manik and other is Manik Bhuya. Now he says, my lord, that 6 persons have assaulted him in this, because we'll exclude the absconders also he has named and including the juvenile. So we'll, after exclusion of it, 6 persons will remain.
And you also Manik, so Sobur Manik.
The Sobur is again doubtful because Sobur is, there are two Soburs.
Sobur and Manik also.
Manik is 2, but here lordship in the first line he has said only Manik, and in the second he has said Manik Bhuya. We'll take it that he has distinguished between those two Manik.
And Rosid?
Rosid also 2, my lord. Rosid is appellant number.
Rosid Ali Mondal and Rosid Mondal.
Yes, my lord. Appellant
There are
number 2
two
and
people.
yes, 2 people.
Okay.
So this Rosid
so
and Sabur.
Therefore, these also doubtful. Which
Doubtful.
one?
Rosid and Sabur, these
Ambiguity,
two doubt. Now, this most important, will for the time being, we'll assume that he has spoken the gospel truth, that he has been assaulted by this accused appellants
Yes.
who are mentioned here.
Yes.
Then your dear lordship will look for it, that whether there is injury report in case of PW number 3. And my answer to is that there is no injury report of PW number 3. Your lordship will kindly look into the deposition of PW number 1. I'll in PW1, my lord, if your lordship.
Yes, PW1.
Yes, my lord. PW1 deposition, your lordship. Who are the person whose injury reports are there, my lord? First is, my lord, page 9, my lord.
Nurul Islam.
Nurul Islam is PW8. Then Moinul Haq Mondal, my lord, PW number 4. In the middle.
Nurul Islam is PW8.
8. Then Moinul Haq Mandal, PW number 4.
Moinul Haq, no.
Then there is also another at page 10, your lordship will find Abdul
Abdul
Mannan Mandal. Malat, he has not even cited as an eyewitness, Malat. Although the injury report is there of this Abdul Mannan Mandal, he has not been cited as an eyewitness, Malat.
Even a witness.
Huh?
Witness, no.
No.
Therefore, no, nothing about this Mr.
And there's another one, Malat, Nurul Islam, PW 8, yes. So PW number 3, although he says that he was assaulted by the accused appellant, but there is no injury report. So what will be the conclusion, my lord? It will be at best simple hurt, because if there is a grievous hurt, then my lord, it has to fall into those 8 hurts which are mentioned in section 320 IPC, my lord. So there is no evidence on record to suggest, or medical evidence or any other evidence to suggest that the PW number 3 had sustained grievous injury. So it will be at best a case of simple hurt. And your lordship knows that in case of simple hurt, it is a bailable offense, and maximum imprisonment is, my lord, may extend to 1 year or with fine, which may extend to 1,000 rupees. And we have all this appellants, most of them have undergone almost 4 years in custody. So this PW3, my lord, that assault part will go, my lord. Even if your lordship for a time being believe the deposition of PW number 3, that he was assaulted by the 6th person.
Yes, then
Your lordship will look into the next line, my lord. Just a moment. Just a moment. Then your lordship will see. This is important, my lord. My son Soidur Rahman. Page, my lord.
14.
Page 14.
yes.
My son Soidur Rahman. So your lordship will kindly take note of the name
Yes.
of the father is telling that his name of the son is Soidur Rahman. Because once he says that Soidur Rahman was killed, your lordship will definitely try to look into the postmortem report, and your lordship will not find that postmortem report. So I'm just pointing out, your lordship will therefore take note of this name. My son Soidur Rahman was assaulted on the right ear. So the first injury that was being told is that his son was assaulted on the right ear. That is injury number 1. He fell down. Okay. Then accused Sabur Mandan then struck my son Saidur by means of dagger. So Sabur was 2, appellant number 1 and 2. So he specifically says that accused Sabur then struck my son Saidur by means of dagger. That is injury number 2. Because I will correlate with the medical report and the postmortem report, my lord. Then the injury number 3, your lordship will find on the same son. Accused Nurul pierced the belly of Soidur by means of phala. He died on the spot.
So Nurul pierced
Pierced the belly. That is
Nurul is accused number?
Nurul is, my lord, appellant number 4.
And Safar?
Sabur is, my lord, 2 Sabur.
No.
Appellant number 1 and appellant number 11.
Safur.
Subur.
Oh, is it Subur?
Sabur.
Okay.
Appellant number 1 and appellant number 11, my
Oh,
lord.
it is
Subur.
written Safur, no? That's something.
Original, my lord, because the handwriting is bad now, I have tried to, it's Sabur, my lord. Original one, your lord will say. It's
Subur.
just I will check.
Subur,
So was assaulted on the right ear, he fell down. Accused Sabur, my lord, yes.
So accused
It
Subur.
was because F type, the B was, that's why it came
So accused Subur will be either A11, A1
or A11.
or A11.
And then my son Saidu by means of a dagger.
Then Narul,
Nurul, appellant number 4, pierced the belly.
pierce.
Now, my lord, this is the first time, my lord, which was trying to be developed by PW number 3 in the court. And this is a major
When they
contradiction.
pierce belly, this is injury number?
3,
Okay.
on number 3. So your lordship will see. Now, if this was made, these statements are made in 161 or in 164, then I'm finished. If it was mentioned in the FIR also, then I'm finished. But this is a major omission, my lord, or I would say contradiction which was proved in accordance with the section 145 of the Evidence Act. Now, your lordship will see so far in regard to this statement, what was made, what was asked in the cross, my lord. Well, it is in the middle of page 16. Original one, your lordship will look.
Page,
In the type copy, it is 16, but your lordship has to,
what is the statement?
yes, my lord. In the cross, my lord, it is said,
I did not state before, no.
it is not a fact that I did not state.
I did not state before the police.
Police that Sabur struck Saidu by means of dagger.
Okay.
That is number one.
So,
Then again, next one also, your lordship. It is not a fact that I did not state before the police that Nurul pierced the belly of Soidu by means of pala. Now, this is the first step taken in terms of section 145 of the Evidence Act. Now, your lordship will look into the IO, whether this was put to the IO or not. Because even if I leave it here and I don't put it to the IO, the contradiction will not be proved in accordance with section 145 of the Evidence Act, my lord. PW 16, my lord. PW 16.
so it is PW 16?
The IO, because I have to put the question to the IO, my lord.
44.
You also stated, he didn't say.
Page 42, your lordship will see. 42. That is PW number 15. I'm sorry.
Page,
Page 42.
so I also,
I also said the witness Moidan Ali Mondal did not state during investigation before me that the accused Rashid assaulted his son Soidur on his ear. The aforesaid witness did not state before me during investigation that the accused Sobur assaulted his Soidur with dagger. The aforesaid did not state before me during investigation that Nuril pierced the belly of Soidur by means of phala. The aforesaid witness did not state me during the investigation that his son had action to left the place. So these are the first time that was made in the court. So this contradiction has been proved in terms of section 145 of the Evidence Act. And there is a reason behind it. My lord, why this witness did not say? Because one, when he gave his statement under 161, he was not aware of the postmortem report probably, or the injury sustained by his son. Later on, probably he had the occasion to see the postmortem report or the statement of the doctor. That's why he has given this, described this own number 1, 2, and 3. Your lordship will now see the evidence of PW number 2. Doctor who conducted the postmortem report.
2.
Page 11.
page,
Page 11.
Dr. PW
2.
2.
Who conducted the postmortem on the deceased.
What does he say?
Now, in the postmortem report, your lordship will find, when your lordship had looked into the deposition of PW number 3, he said that his son name was Soidur Rahman. But your lordship will find here that there is no person by the name of Soidur Rahman whose postmortem was exhibited by or executed or proved by PW number 2.
No, posted, so he, no,
Now, your lordship will see. I look at page 11. I will give that.
page 11 on.
First one is Rohijuddin Mondal. my lord.
Rohijuddin Mondal.
He is husband of PW number 10, my lord, and uncle of PW 3, my lord.
Number 1 is Rohijuddin Mondal.
Yes, my lord. He is husband of PW 10 and uncle of PW 3.
Husband of
PW 10 and uncle of PW number 3.
then
Sahid Hussain Mondal, my lord.
Said
He is brother of PW number 3 and 4.
brother of PW.
Number 3 and 4.
Then who is the other one? Third
Then
one?
the
Mannan.
Mannan Ali Khan, my lord. He is uncle of PW number 3, my lord.
And Said.
Said Ali Mandal is my husband of PW number 9.
So he's the son.
Said Ali Mandal is husband of PW 9.
Mhm.
So if you go strictly by what PW number 3 is saying, my lord, your lordship will not find the exhibit done by PW number 2, the name of this deceased. Now your lordship will see the postmortem report also, my lord. The postmortem report starts from page number 93.
Shahid, my son Sahidur Rahman. So Sahidur Rahman, according to was killed, no?
According to PW number 3, he was killed.
Killed.
And it is a fact that he was killed.
Huh.
But the father telling being killed, and I am saying that he is being killed will not do. They has to make the proper exhibit and has to prove it by record. Now your lordship will see.
So you mean to say that these 4 are different persons?
Yes, someone else postmortem report. not of this.
Rohiduddin Mandal,
But-
Syed Hussain Mandal,
Yes, Malad,
Monna
yes.
Ali Khan, Syed Ali Mandal.
My lord, I am taking all the possible grounds, but when one good ground is good, the other ground your lordship may not look into it. But I don't know what your lordship is thinking till the judgment is delivered. So I have to take all possible grounds, and which of these grounds will click, I don't know, my lord. So your lordship will kindly look at the postmortem report at page 93.
So 1, 2, 3, 4, therefore,
This person's name, there is no postmortem report of Saidu Rahman. And there is no evidence on record to show that this Saidu Rahman and the postmortem report which were exhibited by PW number 2 is the same person.
Father's name is same.
Now that's why your lordship now look into the original postmortem report at page 93.
father name is same.
No,
Please.
my
No,
lord, there's-
page number 93, Lordship.
your lordship will see. Your lordship will see. Your lordship will see.
Postmortem report.
Sahid Ali Mandal, my lord.
Page 93.
Yes, my lord. Page 93, my lord.
Wait.
Sahid Ali Mandal, 40 years, son of late Alimuddin Mandal, my lord.
Just a minute. Page
What
93.
animal? Moidan Mandal.
Huh?
Moidan-
Exhibit number, my lord. 12,
Oh, 93.
Page 90.
93, exhibit number 12, my lord, the postmortem
Page
report.
93 is blank page.
My lord, the broadsheet will be there, my lord. Postmortem,
next
first postmortem.
Broad.
Mine is 93, then it may be 94, my lord.
Okay.
I'll correct it.
Yeah.
The first broadsheet, my lord.
Broadsheet is there, yes.
Yes, now your lordship will see. Sohid Ali Mandal is there.
That couple of.
Original, my lord, original will be there on the record, my lord.
It took Jahid.
Original will be more legible, my lord, and it will, in photostat, some portion may get cut, but in the original, it will be there, my lord.
Syed Ali Mandal.
Sohid Ali Mandal, he is the husband of PW number 9.
Sahid Ali name.
And then.
Then the next postmortem report, your lordship will go.
Manan Ali.
He is the uncle of PW number 3 and 4.
Yes.
Then your lordship will see Syed Hussain Mandal.
Huh.
Your lordship will see Syed Hussain Mandal,
Son of late Moidan Mandal.
son of late Maidan Mandal. My lord, this, if you take it, even if you take part of the name of the PW number 3 also, on the day when the postmortem was done, he was living. It is not that he died when the postmortem report was done, that he was dead. And this name also doesn't match. Then your lordship will also see the next postmortem report. It is of Rohiduddin Mandal, husband of PW number 10. So although the PW number 3 is saying, but saying that his son has died, or even I may know that the son has died and was killed by someone. But there are serious lapses on the part of the investigating authority during the initial stage of investigation, and even during the trial, there was no effort by the prosecution to prove that the son Soidur Rahman, who was referred by PW number 3, is the same person of those whose postmortem report has been exhibited. So in that case, madam, so far this part is concerned, this benefit of doubt will go to the accused appellant. And so far that contradiction is concerned, your lordship, I have pointed out only so that contradiction, your lordship will not look into it because that is a serious omission on the part of the prosecution.
So this is page number, page number 93. 93. Mannan Ali Khan. Mannan Ali Khan is-
Because in the CRPC, if your lordship looks into the explanation to 162,
So this is.
your lordship has read it. So this will fall within that explanation. That is what I am trying to impress upon your lordship.
Improvement, embellishment.
But this is not a,
Not mentioned in the 161.
this is
I'm also contradiction.
not only minor improvement, embellishment, exaggeration, your lordship will ignore. That we all know.
Omission.
Omission. Omission, which goes to the general that what. Exception nahi hai kya? CRPC कौन सा पढ़ने?
CRPC.
मेरे को उसमें निकाल दो ना, iPad में निकाल लो. Explanation to section 162. your lordship. मेरे को
164.
CRPC नहीं है.
Significant
Significant.
and otherwise relevant.
Yes, that's the language. So
Significant.
this is a significant omission, my lord. And probably, my lord, he had occasion to see it. My lord, I'll be fair to the prosecution also for the time being. This will go ultimately. This part will go. But even then, this witness had the occasion to see the deposition of PW number 2, or he had the occasion to see the postmortem report, which will match with the injuries that he have given description. I'll show it to your lordship. Let it be me be fair to the prosecution also, my lord. Your lordship will kindly see the deposition of PW number 2. Page 11.
Yes.
Now, if your lordship looks into the evidence of PW number 2 at page 11, your lordship will find, on the same day, I examined Syed Hussain Mandal, 35 years old man, and found the following. One male dead body of average build, age approximately 35 years, rigor mortis present. That means it has that stiffening of the body. Then split earlobe, because he has said the first blow was struck on the ear. So split earlobe. So he was trying to relate this injury with his description deposition in the court. Then blood clot present. One incised own bone deep over lip vertex, that is top of the skull. But of course, there was nothing to mention that there was injury over the skull. Then blood clot present. Then next page, your lordship will find one penetrating wound in shape 2 centimeter diameter over right loin deep into the abdomen. Then on dissection of wound number 2, intracranial blood, that is rupture of the blood vessel with clotted blood is seen. On dissection of the wound number 3, intra-abdominal blood was seen with peritoneal tear beneath the injury. No intestinal injury was seen. All the injuries are antemortem in nature. In my opinion, the cause of death was due to shock and hemorrhage due to multiple injuries. So he was trying by implicating Shobur and the other Nurul with these injuries. That's why this description, which he has not given in the 161 statement, he was trying to give it first time in the court, so that his ocular testimony matches with the medical evidence, my lord. So this witness, my lord, is with our utmost respect, I submit, is wholly unreliable. Then your lordship will again go to PW number 3. My other son, Sakat Mandal, reached the place of occurrence, hearing sounds from the nearby place where he was plowing. This Sakat Mandal is also not a prosecution witness, so this line will also have no relevance. I was asked by my son to leave the place. Your lordship will kindly take note in case of Sakat Mandal also that he was not present at the, he was not cited as an eyewitness, my lord, or as a prosecution witness. Then that next line your lordship will again take into note, because I'll not pick up one line and say that this witness is wholly unreliable. Your lordship will look into the entire evidence of PW number 3. Then when I was asked about to leave the place, the accused Rajak Sattar Manik Bhuiya ran from behind. In the original details, my lord, ran from behind.
I mean, they were following him. They were
No,
following-
ran from behind.
Then from, I mean,
Ran from, when I was about to leave the accused, Rajak Sattar Bhuiya ran from, 3 accused entered into the house of Ruhis. I saw it. My lord, this is what is again, this is what he is trying to improve is, my lord. The occurrence took place in a place that where he has first described in that boundary of the alley. This house of Ruhis is about half a furlong away from that place of occurrence. This PWD 3, my lord, he could not have been present at the both place at the same time, my lord. Ruhis died not at the place of occurrence, but at his house. So he is trying now to say that I saw them change Rajak Sattar Manik Bhuiya from behind. The 3 accused entered into the house of Ruhis. I saw it. Now, so far, my lord, this house is concerned, my lord, the PWD 10 states that the place of occurrence is a half mile from the village. And Ruhis died at the house. My lord, I'll come to that later on, but your lordship will kindly take note. Here also, he is trying to make improvement. Then I came to the house. I lodged Hazaya with Shipsa police. The Hazaya was written by one writer called Murad Sheikh. And writer was also not examined by the police. It was written as told by me. Exhibit 13 is the FIR, exhibit so-and-so, so-and-so. My brother Sahid, my uncle Ruhizuddin and Mannan were also killed. I know the accused person present in the dock. The accused I name are in the dock. Again, here also he is making a mistake that the here he says the accused I name in the are in the dock. All the accused persons which he has named in examination shift can be in the dock, because one is a juvenile, the other one has died, 2 are absconders. So how did he see all these accused who are absconders, died, and he must have some invisible power to see all of them. So this is again also not correct, my lord, that I have, he saw all the persons named in the dock. Just an omnibus statement he is making so that all the persons are roped in by virtue of 149 IPC, my lord. Now, only in this case, your lordship will take note in the cross, because his description of the starting of the offense of the occurrence and a PW4 are different. So your lordship will see what he says in the cross, my lord, how it is started. I cannot say how many days before I was called for the measurement of land. First line. So measurement of the land took place before also. So when there is previous enmity or dispute in regard, your lordship has said that if there is same family members, whether it is 5, 7 and all, there must be some common object in for that to constitute that occurrence or the language that used in section 149. Here to bring it, my lord, your lordship will say, I cannot say how many days before I was called for the measurement of the land. 5, 6 days before the occurrence, the land was demarcated by Noble Mandal. So he knows all these persons who are involved in the demarcation and all. So when there is a case of previous enmity, my lord, in one of the judgment of the Supreme Court, it says that previous enmity is a double-edged sword. There will be always, on one hand, there will always be an effort to implicate the persons who are involved in that enmity, my lord. I saw the accused Ainal and their company, Azizur and Razid. They did not plow over the land at the same time. Altercation occurred between them and myself. It continued for 5, 6 months. After my arrival, now you all will see, after my arrival, Ismail, PW5, deceased, Sahid Ali, PW13, Mannan, deceased, Sohidul, Ruhis, deceased, PW 14, Moilan, Nuril, Appellant, Mondal, Nuksan, and Hakim came. Then assault was started. Ainal got injury to some extent. But he will not say who has caused the injuries to Ainal. Ainal was not taken by Rohizuddin. It is not a fact that Ainal was taken. Villagers from different villages arrived and attacked our village. Rohiz was killed in his house. You also will say that house again. The wife says that is 1.5 furlong, I think, from the place of occurrence. It is not a fact that the accused did not go to our village. It is not a fact that the accused did not assault us. It is not a fact that Ainal company was severely assaulted by us and tied up at this. It is not a fact that I did not state before police that Rashid assaulted my son. Then this part I have already read. It is not a fact I did not state before police that Rajak, Sattar, and Manik ran behind and entered into the house of Rohiz. It is not a fact that Rashid, Sabur, and Nurul assaulted my son. It is not a fact that 4 persons were killed at the place of occurrence. It is not a fact that incident of assault took place in our village. It is fact that no incident of assault took place with the accused. Papers relating to the land was not given to the police. We did not have our papers. In between Veramara and Dinawara Alga, no land is possessed by Diwana Alga people. It is not a fact that the accused has been possessing the land in question for long. Land was eroded by tributary of river Brahmaputra. The land appeared 4 or 5 years ago. The accused and we were enjoying the land amicably. Then dispute occurred. It is not a fact that we encroached into the land of the accused for today. Nabal Mondal demarcated the land. This Mondal was also not examined as a prosecution witness, my lord. Boundary line was specified and certain plans were planted to show the boundary. I did not accept the boundary. Altercation occurred over it. Then the incident took place. It is not a fact that we 10-11 persons came and assaulted Ainal, Hussain Ali, Qasim, Ahmed, Yusuf Ali, and Batan Bia. It is not a fact that after the assault we kidnapped Ainal and confined him. It is not a fact that villagers of different villages came to rescue Ainal. It is not a fact that all the accused were there. So, my lord, after filtering all the statements which have been made by the PW3, the only that I feel is that I cannot concede, but I feel that this causing of simple injury may survive in case of the persons where there is no conflict in name. In case of Sabur, there are 2 Saburs. Rashid, there are 2 Saburs. That I leave to your lordship discussion, how your lordship will deal with it. So far Manik is concerned, 1 Manik and 1 Manik Mia. So we'll presume that yes. So causing of simple injury to PW number 3, so far PW3 evidence is concerned, it may survive even if your lordship tries to shift the grain from the chaff. Yeah. Then your lordship will look into the next deposition, that is PW number 4. So when your lordship will look into the evidence of PW number 4, he is an injured witness. So at the very outset, I will say, submit that his injury report is exhibit number, I'll just confirm it, exhibit number, so confirm issue. Moinul Haq. Exhibit number 2, which was proved by the doctor, PW number 1, and it is at page number 10 of the paper book. So when an injured witness is there, one thing is your lordship has to presume that he was present at the place of occurrence. I cannot dispute it. Now, next is whether he is trying to give a true account as to how the incident has occurred, or he is trying to make exaggeration, embellishment, improvements, or is not trying to give the correct account as to how the incident occurred, or whether the entire genesis of the incident presented by him is correct. Now your lordship will see his evidence. Because evidence as to how the incident occurred is different from PW4 and PW9. So you all will see. I know all the accused person present in the dock. Omnibus step. I knew the deceased Sahid, Mannan, and Rohuzuddin Mondal. So far, my lord, the second statement is concerned, my lord. Sahid, Mannan, and Rohuzuddin, their postmortem reports are available on record. I don't find the name of any of the deceased as Sahidul, my lord.
Shahidul.
Yes,
Sahidul
there's no,
means Saidul.
there's no postmortem report by the name of Sahidul, my lord.
Saidul, Sahid.
Sahidul. Sahidul ase. Sahid ase, Mannan ase, Rohuzuddin.
So that Saidul is Sahidul here.
So he's talking about three. Sahidul, there is a comma, then Sahid, Mannan, and Rohuzuddin.
Yes, 4.
I don't find your Lordship, I again check. I too don't find this thing. But whatever, I don't find it. I have made it. You will verify it, madam. I was cutting grass in the field. It was Sunday. Moijan Mondal called me and asked me to go to the paddy field to fix boundary. Madam, Moijan Mondal called me and asked me to go to paddy field to fix boundary. And this Moidal Mondal was not examined as a prosecution witness, madam.
PW3?
No, this is different. Moidan, this is Moijan.
Iman of related. PW3 is Moidan Mondal.
Moijan and Moidan. All proper nouns, there's all confusion about name.
In my book, it is D.
You look into the original. I'll look into the original. Original to some? I'll check with the original.
Moijam.
I'll check.
Moijam. Who is this Moijam?
Not examined.
Moijam.
Moijan Mondal. Moijan Mondal is also not. It's Moijan Mondal. He has not been examined as a prosecution
Moijan
witness.
Mondon.
Mondon.
It has to be Moidan Mondal there. Probably the handwriting is not clear.
Well, there must be evidence from the prosecution to say that this Moijan Mondal is that his name is different. Moijan.
Yes, I can see.
So how can I presume that this Moijan is Moidan Mondal, that PW3?
Achha.
This is it's written Moidan, but it is Moijan.
Not Moidan, man. It's Moijan.
Moijan.
Moijan Mondon. Mondon.
And PW3 is?
PW3 is, my lord, Moidan Ali Mondal. They can't Mohammad Moidan Ali Mondal.
Muhammad Moidan Ali Mondol.
Yes.
And here it is Moidan Mondol.
Moijan.
Moijan.
Not Mondal, my lord. Originally also.
There, these villages, they speak something like that. No,
Ah.
their
No.
tongue are like that.
Yes.
They have to.
Their tongue, they have all that twisted tongue there.
So, my lord, if the name is not mentioned correctly, my lord.
The writing is correct, but then they all pronounce.
So, well, then that
the village
probably,
all like that.
well, probably there was a man name in the village by Moijan Mondal. My lord, benefit will go to whom? To the prosecution or to me? This inconsistency in the name, the benefit of doubt will go to them or to me, to the accused.
You have to be balanced. Because he again refers Moidan as his brother. I went to the paddy field with Moidan, who is my brother.
Daknam. Daknam.
Then you'll also look into that.
Moidan Mondon.
Yes. I came to my house and then I went to the paddy field with Moidan,
Moidan.
who is my brother. He may have a different brother also, I don't know.
L and N are sometimes mixed. In this part of the country, some people say Moidan, some say Moidal. No, L and no. You know, many places in these many communities, L is difficult to be pronounced.
Well, I can understand. Well, if Bhaskar is Bhaskar, for South India, someone may write at Vaskar, Bhaskar.
L and N are, see, if you go to Manipur and Nagaland,
My lord,
L and N.
but I understand, my lord. Proper noun in normal language is okay, but in
And
legal
L-
parlance, my lord, your lordship will whether this
Moidan and-
inconsistencies benefit to whom your lordship will give. But even then, this is one is a, I would say, that, okay, for the time being, we say that whatever he's trying to say is we'll accept it for the time being as stood. Because on
When it's
if this,
Moinal, then this is just hard as Moidan.
I think, well, even if this we accept it, then also the other on other inconsistencies also his evidence will be unreliable, my lord. But I have to point out each and every discrepancies that has that I have noticed with my eyes. Rest I will leave it to the wisdom of your lordship.
So he says.
So he says that
Moidan Mondol.
his description as to going and all is different from PW number 3. I came to my house and then I went in the paddy field with Moidan, who is my brother.
So
If-
Moidan,
if-
but in PW3 also the Moidan.
ठीक है. So here he is talking about PW3 with my brother. Here I say that this Moidan is say PW3, not in the first line, that one.
I was cutting grass in the field, this
Ah.
one.
Yes.
Moidan Mondol called me, so
Yeah.
PW3.
No, that is not PW3. PW3 is I came to the house and then I went to the field with Moidan. This Moidan is PW number 3
Okay,
at base. Your
let
lordship can
us
see.
read again. Moidan Mondol called me and asked me to go to Peripheral to fix boundary.
No, your
I
lordship
came to
read
my
the
house.
original one, my lord.
Huh?
Moidan Mondal called me and asked me to go to Pedifil to fix boundary. I came to my house and then I went to the Pedifil with Moidan, who is my brother. This Moidan who is talking in the second line is, we may say he is PW3. Now, if your lordship will again go to PW number 3. PW number 3 in chief doesn't say that PWD number 4 accompanied him. Then in cross also, my lord. In cross, my lord, he says, after my
Western side is Bangladesh. The
Yes,
Bangladesh boundary.
yes, yes.
So which area is this?
Dhubri.
Dhubri.
Actually, my lord, this could have been more clear. I'm told the counsel who conducted the cross-examination was one of the senior counsel who have a very good practice in criminal law and the courts in Bengal. But some of the probably he must be very busy. Some of the inconsistencies which were there was not clearly brought on the record. You'll also will find it. Which, so in cross, my lord, he only says this PW number 3 says that PW number 4 reached the place of occurrence after his arrival. Whereas PW number 4 says that he accompanied him from the house.
No, it was a Sunday. I was cutting grass. Moidan Mondol called me and asked me to go to Pedifil to fix boundary.
Yes.
Fine. Even
Right.
if he's a different, how does it matter?
No. Then he said, I came to my house and then I
Then
went to the Pedifil with Moidan.
Moidan, who is my brother.
He did not went.
Huh?
He did not go with Moidan to the Pedifil. Moidan went ahead. As per Moidan went ahead. He came later on.
He was, I was called and to show boundary in Pedifil. I saw the plan. How do you say he went ahead?
That your lordship will find in the cross. After my arrival, that line, after my arrival in the cross. After my arrival, Ismail, Sahed Ali, Mannan, Sohidul, Rohiz, Moinal, Nurul, Mondal, Nuchan, and Hakim King.
Where is it?
In cross, my lord.
Cross.
After my arrival, my lord. In the original, your lordship. Original, my lord.
You are reading original.
Yes, my lord. Because
You are
this,
reading the duplicate.
Yes.
because all this confusion of the name, my lord.
Altercation occurred
Yes,
after the arrival, after my arrival. Oh,
Yes.
this is my arrival.
yes.
PW3 cross.
PW3 cross.
In the original, what is written? After my arrival.
After my arrival, Ismail, Sahed Ali, Mannaf,
Just-
Mannan.
Just a minute, we are just trying to see the original also.
After my arrival.
After my arrival,
Yes, madam.
after my arrival,
Ismail,
Sahid, Manan,
Mannaf,
Mannat,
Mannan,
Mannan,
Mannan, Sahidul, Ruhiz,
Minal,
Moinal,
Minal,
Moinal. That is PW number 4.
where is
Nurul,
Moinan?
Moinal, that is Moinal.
Moinal,
Nurul, Mondal, Nurchan, and
Yeah.
Hakim King.
Moinal.
Sorry, Lordship. This is
Who is
Moinal
it?
here. Minal hai. Rohis.
Rohis,
Minal or Moinal? In the.
Minal,
Moinal, there's no
Looks like
witness by the
Moinal
name of
also.
Minal.
Now he is taking
It
it.
looks like Moinal also.
Some what
Hmm.
Moinal? Original of Milan, Minal.
Rohis, Moinal.
Mondal, Mannan, Mondal.
Mannan Mandal. Hmm. Moinal.
Moinal.
I'm looking at it as a Moinal, Your Lordship. The handwriting, it look like Moinal.
Moinal, no. So what do you want to say by this?
That means he did not accompany PWD number 3 to the field. PWD number 3 already went with Ainal company and they were they. They came later on. So he is also not giving the true account of the occurrence.
Who?
This PW number 4.
P number 4, I came to.
I came to my house, then I went to the paddy field with Moidan, who is my brother, Said so and so. The paddy field was in here. Your Lordship will read
So-
his entire evidence, then again I will come to here. The paddy field was in our possession.
So you want to say that Moinal Haq went ahead alone
Yes,
and then it was followed by this group.
yes.
On the other hand, PWD 3 says
Hmm.
that after my arrival, my PWC also says
The PW3 says after my arrival
after
at the place of
Moinal had gone early, that
PW3 has gone alone early. And he says that this PW4 said that I went with PW number. PW4 says that I
I
went,
came to my house, then I went to the paddy field with Moidan.
that is PW number 3.
We may be going early ahead and others are following.
No, that is not the evidence, fellow. That will again presumption.
Not a big contradiction.
You'll also see, you'll also read the entire evidence, then come to a conclusion. PW4 is not law. The paddy field was in our possession.
But is that is it very, very vital, significant contradiction?
Malab, what I am trying to impress upon your Lordship is that all these prosecution witnesses who are trying to give how the occurrence has occurred is not true, is not believable, because they are trying to suppress facts from the court.
Because they are testifying after 4 years.
4 years also, but I will not test their memory. That whether after 4 years they will remember all these things or not. But
I don't remember anything after 4
Okay.
years.
so your Lordship will read the evidence as a whole. Why pick up one line and we come to the conclusion? We'll read the whole then.
And then yes,
Then
So, after
but
you-
see, what I'm pointing out, all this minor inconsistency or your embellishment or exaggeration is that it will be the sum total of all this your Lordship has to take. I
the
can't.
fact
read
that
it-
whether you went ahead earlier but then you went, everybody went.
Yes.
One may have gone a little bit
Yes,
early,
yes.
but
But
presence.
because this inconsistencies have occurred because they are all trying to suppress the real truth.
No,
that's
they are
right.
speaking after 4 years. So
No,
they don't have a
how
compu-
can they forget
they
that?
don't have a computerized memory.
No, my lord. Then how can they forget that Ainal company has sustained, some of the witnesses say that Ainal company has sustained injury. They are suppressing again that they will not disclose who has caused the injury on Ainal. There's no explanation as to how the injury was caused on Ainal. Then number one, they are also suppressing the fact that that Ainal was in their captivity. So
No, that you can say.
yes, So
all
that's
those,
why.
all those very glaring
Yes.
contradiction you say, but
Yes.
then who went ahead that, and sometimes they walk, "Arey, ahi bo, chalo." He went there, he reaches there a little bit, a few seconds, then they come, same
Yes,
thing.
then, even then, if your lordship will.
It is not that they went,
Yes.
one day ahead and they came later on, one day after, nothing like that.
Yes.
More or less,
But that
similar time,
but
maybe
that-
he reached little bit early.
Yes, madam.
And then he thought, we thought, I remember the 4 years, okay, yeah, we went together.
Your lordship is
All
that way, is correct, that we may not remember with mathematical
Ah.
accuracy or.
After 4 years,
After
yes.
4 years, we'll.
They remember
But-
that we went to, oh, acha, we
Yes.
went together.
Yes.
Sometimes, oh, we went to the same car. No, he was following the car. There's no contradiction.
Yes, so your lordship will.
We went to that picnic.
Yes, yes.
I don't remember with whom you sat in the car. Maybe 2, 3 cars. You may be sitting in the same car, but you forget, no? Oh, we went together. So it doesn't, the factum remains that all these people went. One person perhaps landed early, some followed. So not because how does it relate to the actual incident? It doesn't have relevance to that extent.
Okay.
So let us, so.
Then we'll go to.
Yes, yes.
But whatever your lordship will take.
Correct, correct.
The pedophile was in our position. Next
Okay.
slide,
Yes. You are reading 4, na?
4.
Yes. Yes, yes.
The pedophile was in our possession. I saw groundnut cultivation there. Some of the accused were plowing over the lands and some others were making ali. Mondal private and engaged Mondal for demarcation. It was written as man, but in the original I find. Not here. Here the plus again.
Ali Mondal primarily engaged in demarcation.
No, the language.
We told not governing was required to engage. What is this? Engage.
And others were making
Government Mondal.
Ali. Mondal privately engaged in my photostat copy, that is missing, my lord, because that is originally your lordship will
The
say.
peripheral was in our position. I saw
Groundnut cultivation.
groundnut cultivation.
There,
Some of the accused were plowing
over the land.
over the land, and some
Some
others
others were
were
making
making
Ali.
Ali.
Ali means.
Making means?
Making Ali means the road,
Roads, constructing road.
Oh,
pedophile, that small.
okay, making Ali. Okay, that. Yes.
Then Mondal privately engaged.
Mondal privately engaged.
I think that is Mondal in my
I think.
Privately engaged, huh?
Privately-
Privately engaged.
Mondal for demarcation. What?
Privately engaged.
Man or Mondal for demarcation or?
Privately engaged. Make demarcation. To
No,
make.
it will be Mondal. If you read the whole evidence and all, it will
No,
be either man.
Mondal privately engaged to make demarcation. He must have forgotten to write to. These things happen.
Yes.
We told that government Mondal was required to be engaged.
We told, huh?
We told that government Mondal was required to be engaged.
Yes.
Not bad.
We told that government Mondal was required to be engaged.
We also told that a private Mondal was not acceptable to us.
Was not, here we told not governing Mondal.
We can't blame our court people also.
हाँ,
We also told that a private Mondal was not acceptable to us.
अपने
then-
सवाल पर सवाल है।
Hmm.
हाँ,
Then accused Ainal company ordered the others to catch hold of us and to assault us. Some accused were hiding themselves. Then accused Ainal company, deceased Hussein, A10, Alauddin,
See,
Juvenile.
what P4 is trying to, witness 4 is trying to portray is that there was a jhagra about the demarcation,
Yes.
land dispute. We went, then they said, no, private koribo, government koribo, then. Then these companies started assaulting.
Yes.
Huh?
Yes, only one sided.
One side, correct. Companies started assaulting, then after that, we have started, we also, there was jhagra.
That is.
Huh.
So 149, if your lordships omit, then your lordship has to look for the overtax of each of the.
Why should we omit 149?
Because my lord, if your lordship will look into the genesis of the incident, it is they who started the.
We don't know, somebody started, we are not able
No, no,
to.
you will go by the evidence on record, my lord. Which
correct.
says that
But it
Ainal
may-
company there was no common object to cause murder of anyone.
No, Ainal company might have been detained after he started beating. धरो किसको रखो.
That is not the evidence. Vinyl company was detained first, then 300, 400 villagers of the 3-4 villages came to rescue.
No. He was detained because he was assaulting. That is why. And then Ainal company has a bigger followers. That's why all these 400 people
My
came.
lord, just like we say that a woman will never lie about this chastity. Similarly, my lord, here the wife of the deceased has given the exact version of the
Oh, we
incident.
don't know. We don't know.
My lord,
They-
but that is
there
the,
were- we
My lord-
cannot make a generalized statement.
no,
Women also.
we'll go by the statement that has been on record by the prosecution witnesses, which says that Ainal company was confined
Correct.
first.
Confirm first because he was assaulting. That is why we confirm.
To that extent, there is no evidence.
His group was assaulting us.
To that extent, my lord, I respectfully submit that there is no evidence.
No, we are just trying.
Yes.
What could be the possible scenario?
Yes.
That either, as you say, may be correct.
Yes.
He came to settle ki don't do this, we'll do this through government.
Yes.
Don't do it private.
Yes.
So then dhori lo.
Ah. Well,
And then all things start. Then people heard, oh, Ainal company has been detained by this group. I rescued them. Mob came and there is one scenario. Another scenario is that yes, they went there to the place plowing. That who is there? Some people are plowing this and that. My plan. Why you doing this? And then Jhagda Jati in that place. And then Ainul also assaulted.
they took him into
And then
captivity.
he was trying to assault.
Hmm.
You want to assault us? Dhoro. And then they
Taken
took him.
To the house of Rohijuddin.
Harojuddin, Rakho.
Then villagers came.
Then villages. This also can be seen, but it doesn't mean that the witness party had started the jagra. It may be
No, madam, it was I would say at the time.
genesis. Very difficult to ascertain the
Yes,
genesis.
But your lordship has to ascertain that common object to cause the death.
No, because you people didn't give any evidence. No,
No, my lord, because.
therefore you don't give any evidence.
No,
You
there
are
was a
trying to
cross case,
extract.
my lord,
You are trying to extract the evidence from the PW.
Yes, yes.
And you want to extract some facts.
Because in the suggestion from day one, we have, what is the benefit of suggestion? From the suggestion itself, we are trying to portray a case that it was you who have confined Ainal company, and that's how the fight had started. And that's the evidentiary value of a suggestion I will respectfully submit. That is the main objective why we give suggestion during cross-examination.
But correct. But suggestion you can make 100 suggestions. But what is your plea?
Well,
Now, if the witnesses PWs their evidence,
Yes.
whether we believe or not, there's another thing.
Yes,
Evidence. He comes to the court, said, this is what has happened. Your is suggestion.
yes,
You're trying to throw all doubts, smoke.
great doubt.
Uh,
Because, my lord,
but you
convict
you
and
also never led any evidence.
Yes.
You had an option to lead. Nobody stopped you.
yes, yes,
Of course, we don't also impose no obligation.
yes.
But you had the option. You had the option to lead. So if you are able to bring out very clear inconsistency or contradiction, demolish the prosecution case, fine,
Yes.
you go. But if you are not able to demolish, if you are not able to bring the inconsistency, then you run the risk.
Yes.
Because-
Even if I don't put the contradiction properly, then also I run the risk.
Yes, yes.
But in case of PW3,
Because if it is a kind of, if you are so sure that you are also innocent, you could have also led evidence. He said, you see, I am doing defense. I was picked up. We are not saying that because you do not do, so we are going to put the blame. That
no,
we can't do
we have
that.
started with only PW3 only. We have not read the 16 witnesses. We have just started with one witness, and I have pointed out the major contradiction in his
Okay,
witness in
now-
regard to killing of
Now that
his son.
that goes to what the plea of you said you tried to complete within 1 hour.
Requested you
beginning.
rather.
Huh?
And the cross case, I think last occasion he said that it was dismissed.
Because Ainal company also had died, madam. All this person went to jail. So nobody had lost
There was a
interest.
cross case and then it was dismissed.
Of course, madam, what has happened? Madam,
I see there was a cross case also.
yes, yes,
You have filed a cross case.
yes, yes.
On that in that case, what happened?
Madam, Ainal company died during the investigation process. All these
Okay.
people then that died in natural death, madam.
And then the case was dismissed, perhaps on merits.
No, don't say it on merits, unless you know the judgment.
Actually, there was no judgment.
Probably there was a judgment, madam. We did not have the occasion to see it because. see,
Because you did
madam,
not bother to see because you are is not in your favor.
no, it-
Otherwise, you would have
no,
brought that
no, it
document
was-
right
yeah.
now.
Last
And-
week, I remember him saying that it was dismissed and I've noted down.
Yeah. Now she has got a different memory, which I am not, can't have that much of
No,
memory.
okay, what we are thinking is that now we are in PW3 and PW4.
Yes, but other
Mm.
witnesses are not very, of course, the wives are there. And three of them.
No, we have all, no, we just, because we thought we would like to finish it before puja, but that's what I'm thinking, whether we will be able to do it or not.
My lord, I have told at the very beginning itself,
Yes.
my friend was also there. In one court, it took 5 days. In one court, my lord, 3 days. And in another court, I think another 4 days, all gone to waste. And in one case, the judgment, entire judgment was dictated. We are all acquitted. Suddenly she says that notice to the informant has not changed. Then we took steps on the informant. Then we find that the informant has died.
So I requested him, so this should also not go to waste. So if we can just summarize.
It's
and,
my learned friend has an opinion that all my pointing of this contradiction is a waste of
No,
time.
no, what I'm saying is.
Then I'll not comment
we
on
should
the
squeeze-
our expertise.
we say it differently. What I'm saying is, if we can squeeze, like your lordship said, and finish it in today.
How is possible? How can I excuse?
Today.
I'm trying to be very fast in what I'm speaking. I'm going in a, what you say, that the speed of the internet, I'm a little bit faster, but even then it's not possible.
Today perhaps we can,
Okay, even so,
because apart from 3 and 4, the relevant
And your
witnesses.
lordship, if I take your lordship to the other evidence also, your lordship will find there are major inconsistencies. And the only PW 3, 4, I have only just pointed out, my lord.
Others
Can
are
you,
short.
are you good, you are a good photographer. So you will be able to draw also,
The crime scene.
crime, the contradiction, this,
Mhm.
a PPT. In fact, see, we can use this
Yes,
technique.
yes. But I think we have given a
No, for example, if you have a,
Even I have.
chart, I think we have given, man.
Even I have who had said
Chart.
what.
I think there is a chart.
Lots
Is it
of charts were earlier changed.
Yes, even I have again
no,
prepared.
that will help us in narrowing down. Now, obviously, we'll go through all the, see, all the evidence. There is no question, we will not, we have to go through.
This
Like-
chart, one chart
This is not my chart. It is. This is also his, the
This
big
is a
one.
big chart,
This is also his.
yours, no?
बड़ा वाला chart दिखा. नहीं, ये वाला छोटा वाला.
My
There is a
chart.
big chart,
Yes.
Now, in that chart, your lordship will see.
yes. Code, अपना पैसे जो, नहीं.
There are 2 copies are there.
हाँ,
chart number 8.
yes, in fact, we should have started from this chart, then we'll know. Because you have done a lot of meticulous work, we are saying.
Yes,
This you have done, no?
Yes, sir.
So if you are able to put in one canvas, the easier, that's what.
Madam, that's why, see, madam, the only thing is that in this case, what I find, I have to show your lordship the major contradiction just now that I have done in case of the son of the PW3. So if that, if my friend can improve on it, she can improve it now. So that your lordship has both the views at that point of time only, that in respect of the son of the PW number 3, which I am saying that this is a major omission and which is, which covers by the explanation of 162, this court can look into. So far the son of PW number 3 is concerned, and this,
Because then only with these 2 days, do you think possible?
no,
Conclude?
no.
No.
My
Other evidence are shorter. 3 and 4 are the major.
my friend is very optimistic, but she will also say, in one occasion, we took 5 days, in some
Yes,
we
yes.
took more than 3-4 days.
Because here it is 3, 4, 5,
witnesses.
6, 7, 8, 9, 11, 12,
13,
13.
yes.
So 13 witnesses are being considered.
14 is the inquest, 15 is the IO, 15 is the person, one of the IO, and 16 is the IO of the re-examination and all. So. And we have given other chart also, my lord.
Huh?
where-
Other chart also?
Yes, yes, there are lots of charts, man.
Okay, let us see.
My chart, there is only one, there is a.
Let us see the other chart. What is the other chart that do you have?
Tomato.
Your lordship has
Detailed
that-
particulars of this one, you made this.
No, that is in regard to that sequence of dates.
Okay,
Whether this chart is there or not.
let us see the chart.
আছে এইটো, মোটাটো আছে সেইটো।
You'll also kindly see this chart is there or not. এখন চকচোন। নে ঘূৰাই লৈ গ'লো। Others will make it after vacation, madam.
হয় দিয়া।
This is of course marked my office copy.
আছে নাকি? This something like, আছে, let's check.
We had earlier done it in this way, madam.
Okay. This is your copy.
Yes, madam. Earlier we had,
If you take your copy, then how will you submit?
no, madam, we had earlier made it in this way, madam.
No,
Even I have his copy, I can. Give
no.
it to your lordship.
No, because this will be helpful.
Yes, madam.
And because this will help us pinpoint the area
Yes,
for
sir.
consideration. Asane ki nahi. You must have your computer. must
Yes,
be
yes,
there.
yes, yes,
You
yes.
can retrieve it and
Yes,
give a fresh copy. No.
अच्छा, okay, chart है तो। ये नहीं, और नीचे वाला दिखा। Apa dia? Nah, lagi. Benda orang motion point.
I think you better give, this will be helpful.
Yes.
Yes. The chart
is in the
record, yes.
আছে মোটাটো এখন আছে।
Yeah.
Yes.
Let's
I
help
have
us.
one of his.
We had made around 8-10 charts, but I don't know where it has gone. Because this was probably what your lordship was suggesting. This, if I make it in this way, then it will be helpful for your lordship. We'll do it. Ma'am. The sound is not there.
You have mentioned over here, see.
Yeah.
PW3, Moinuddin Ali, appellant is named FIR along with 18 others, omnibus allegation FIR, we have to assault. No specific activity appellant in the FIR. The court mentioned, in the court mentioned, Sabur assaulted deceased by dagger, since it was made for the first time trial and not with IO, the contradiction was proved by IO. See, it makes all this
Easier.
easier. What we have argued for 1 hour, we have put it in this 6 inches square, this space.
So I said he can squeeze.
We'll do it. Ma'am.
I think this will,
Well, we'll do it after vacation. or
no,
later, yes.
no issue, because then
will-
we can,
We'll try to put, I don't know, but we'll try to put in PPT also if it's possible.
whatever, just see,
Yes.
because nothing else, just a sheer number of similar sounding names, for example. You said that Saidur, two like that, like A1, A2.
Well, before I took up this case, but I was thinking of even going to that place of occurrence to have a recce of it. Normally, which I do before I take up trial.
Normally,
cases.
it is very
Yes,
helpful.
Yes,
If
we
you,
do
if
it.
one is a criminal lawyer,
Well, we do it.
visiting a place of occurrence, it gives a first-hand idea what is actually
Yes,
happened.
Yes, madam. And
Because-
we are here to assist the court.
Correct.
But there is a risk, madam. Recently, I went in a similar case to recce a place in Gwalpara, Sapuri area. Well, the other group also came. Then I fled away from that place. Who is this person inspecting, taking pictures in his mobile of the bill, the house where it, then I find that this sketch map where it is says the place of occurrence is there, it is different. Then the narration that is given is different. Then the man was stuck with a boulder. How come the boulder was there? Because there was a stone quarry by the side of there. The person may have fallen on that heap of stone and died. But that is again risky, that sometimes the lawyer may lose their life also going to do a recce, because it has happened once in Nalbari.
Of course, then you have to go along with your clients, obviously. I mean,
My client will be 4, there will be 10 from the other side, then it will be trouble.
but it's always helpful.
Yes, ma'am.
If you
It's very
see-
helpful. Very helpful. Sometimes they, because on the dictation of the some people, they will say that there is street light in the place of occurrence, but when you go and see, there is no street light.
No, I've been because I've been also in some
Yes,
of these
yes.
commissions. So we used to visit commission, obviously you have to visit.
Yes.
If you are a part of the commission inquiry, no? Normally it is visited. So we, first of all, we do a, first visit the place, then recording all the evidence starts. Then you have an idea, okay, this is the place.
Yes.
Yes, then you can see, oh, from there, these people came here, this is, so this is the distance, this hill, this is a valley, this is a, see,
Yes.
agricultural, so you have a, you can appreciate the evidence much better.
In Manipur also, well, these extrajudicial killings cases and all, where the commandos have killed in fake encounter. Well, I have, with Riggs also, I have visited the place to see. They said that it was raining at night, 2 o'clock, and there were 30 AK-47 bullet injury from where the bullet was fired and all. If you go to that place, you can have always have a better idea. Your lordship is right.
Then we'll continue up the vacation in that case. In the meantime, we'll already one copy is there. They will make, or if we can furnish whatever.
I'll find a fresh copy.
Even my. copy.
Acha.
I'll improve on this copy if it is because I'll have time during the vacation.
Yes,
Then
yes.
we'll
Then we'll have a, see, a picture
Yes.
in front of us.
yes, fine.
All this contradiction, we can just flip through. Because the problem is that, see, when we hear your case, after this, we'll hear another case, similar sounding names also. Something, and then we sometimes get, so if we have this specific
Yes,
see,
sir. We'll do
pictures
it, my
before
lord.
us.
We'll do it, my lord. But that's always helpful, my lord. Otherwise, I will argue, then your lordship will not include in the judgment. Then again, we have.
That
to
is
go-
why I normally dictate what is the fact and submission. Then,
Better. Even I have made the charts.
yes,
My chart will show, I've taken, I'm
Yes.
relying on a Supreme Court judgment, Vasanti's case, Lordship knows.
Yeah.
There it is said in case of mob fighting,
yes.
the proper procedure would be that at least more than 2 witnesses should name the common names. This.
Sure,
yes,
there's a
uh-huh.
sure kind of way of,
Sure, and this is what
yeah.
the Masalti, the case Supreme Court has relied on, and later also I've seen many cases where this procedure is relied on.
But here
So
also,
here-
since the witnesses are inimical to each other, here also lordship will always look for more than one for corporation, because here they have this inimical witnesses, your lordship can rely on the sole testimony of that witness.
So my chart includes those, and also 161 what they have named, and before the trial court whom they have named.
No,
these
161,
are-
your lordship will not look into it.
But
That is gone.
then see, there is a risk of looking, no, because there is an absolute bar.
Yes, ma'am.
Huh.
There shall not be any purpose. The word is very clear,
Yes, ma'am.
categorical.
Yes, ma'am.
Shall not be used for any purpose except provided. For
Yes,
what provides, what?
Contradiction.
Contradiction
Contradict.
or improvement. Contradiction amounts, what is a contradiction is also defined under explanation, which is not mentioned. You mentioned this amounts to contradiction. So we can, for that purpose, we can see, did you mention this in 161? No, there is contradiction on vital part.
Contradiction part also I'm relying on, because
yes.
he just said the overtax were not mentioned to the police.
Correct.
But to the police, the names are mentioned.
Mhm.
They had said all these.
Correct.
assaulted.
Obviously,
Yes.
if I see whatever it is, when a
Uh,
crime takes place, even a mob violence also, even if you are able to identify one person, good enough, as far as that individual is concerned. You may not be able to implicate, because you can't invoke 149, because as you say, unless the clear case, they all came, no, with
Armed with guns.
armed with guns, and chalo, now war,
yes,
declare
yes,
a war
yeah,
on
yes,
this village.
yes.
They've been harassing, let them teach a lesson,
Yes.
come down with a big, then that's a different thing. But otherwise,
Village, this lathi,
Uh-huh.
danda, stick, fala, everywhere you will find.
But then Supreme Court said even at the spur of the moment, common object can be formed.
Where is that evidence? There must be evidence
Yes,
that spur of the moment that common object developed.
yes, we'll see that then.
Yeah.
And then after vacation, then
Yes,
we'll take it up after vacation. Hearing will continue. লিখে দেব। একটা তারিখ দিয়ে দেব, then after vacation.
Yes, ma'am.
After vacation means how many days? Only 2, 3. After vacation means it will be on November only.
November.
But on November first week, I'll
First
not
week.
be,
Acha,
I'll
you-
not be available up to 9th.
Okay, then we'll take it up to 9 then,
Yes.
because see, Earlier, 2 days, nah, nothing will work like
Yes,
this.
and Diwali is also in between, my lord.
These all these
So-
lawyers will come 19, 20, 21. We know what going to be commission.
14th of November.
All the senior council will release their juniors.
Some time is required to file an affidavit, my lord.
9 and 10.
At around 9 and 10.
That-
And for the petitioner.
you're
Oh,
for
we
the
have taken the call.
petitioner. Space tech.
Yes, ma'am.
You are,
I'm for the respondent.
okay. What do you want? What do you want?
Some time is required for filing the affidavit, ma'am.
Okay, Mr.
A.R. Burwan,
Air Bora for the respondent prays for 2 weeks time to file the,
please after.
okay. To file the, in position. Also means
GM Thakur.
GM Thakur for the petitioner. Release after vacation.
Your Lordship, kindly fix a date after Puja vacation.
Wait till 28th of October.
28 October. Yeah.
20,
No,
28 October, huh? What?
I
Which
thought,
date?
I thought, 28
28
October.
October.
28? Yes.
20th Friday.
Okay. Oh, acha. This has to be Monday and Wednesday, no?
Yes.
So then it'll come
On 1st of November.
second of November?
My lord.
2nd of November?
Second November.
Yes, yes.
But in respect of item number 11,
Yeah.
the respondents have just today, my lord, served the copy, my lord, of the affidavit. Probably it is yet to be filed.
Okay.
So can it come up after the litigation?
Okay.
Item 11.
Hi, Mr. Planning Council for the petitioner. Also,
On behalf of Deenat Mine,
your name,
N. Burma.
M.
N. Burma.
Burman from you. On joint trial list after vacation,
9/11.
Right.
With the consent of the other side, I beg to mention item number 13, madam.
Item number 13.
1-3, madam. I
1
pray
3
for
1
week-
3.
I pray for 2 weeks to file my objection.
Mr. Khan pays for 2 weeks to file the objection. This after 2 weeks. How also, Mr. Anybody for the other side? No.
JSK on behalf of SS, right?
Yes, on your, yes. Next.
May it please, your lord. Lordship, I beg to mention item 8, lordship, I am for the respondent. We have today filed our affidavit, lordship, which is not on record, lordship, may fix any date after vacation.
Just a second.
Eight, lordship. Today we
Item
have
number
filed 8. I am for the respondent. We have filed our affidavit today,
Okay.
lordship, which is not on record, lordship, may fix any date after vacation.
Who's for the other side? Who's for the petitioner?
I am for the petition. Yes.
Okay. List the matter on joint trial list the matter against friends. Yes.
14/11.
Okay, right. Deeply.
May I please, your lordship? I beg to mention item number 12. The respondent has filed affidavit in opposition people file rejoinder reply.
Mr.
A. Ahmed
Yeah,
appearing on behalf
Praise
of.
for, praise for how long? 3
After,
weeks time to file a rejoinder to the affidavit filed by the respondent. Also, Mr. S.K. Medilani, Standing Counsel for the release.
lordship, there's another matter, item number 17. It may come up after the vacation.
Item number 7,
17. Item number 17.
written in your palm.
Yes.
Okay. On the prayer of Mr. Swensus.
Highly obliged.
May I please, your lordship? I beg to mention item number 6, ma'am. I am
Item
for a
number
petition.
6.
Yes.
What do you want? What do you want?
No, no, there is a settlement talks between. the
Settlement
both
talk is going on.
Yes. So let the matter maybe come up after 4 weeks. ma'am.
After the vacation, my lord. On any date, your lordship, please.
20, item number 21.
Item number 6.
You are for the petitioner.
I am for the petitioner. ma'am. Item number 6.
Okay. And Mr.
S. D. Roy, my lord.
And also Mr.
A Borua, my lord, on behalf of Mr. KP Pathak.
Parties submit that council for the parties submitted a settlement endeavor is being made. Accordingly, present matter will list of the vacation list accordingly. Yes, next.
9/11.
Obliged, my lord.
Yes,
Daily list for motion, item number 1.
Under application under section 11 for appointment,
relation notice
my lord,
and Mr.
M.
Yes.
Sahewala.
M. Saywal on a council for the petition issue notice over 4 weeks. Miss G. Sharma, accept
Please,
notice, huh?
Please, Norma.
B. Sharma, accept notice on behalf of,
CCC.
CCC,
Oh,
accept,
that is fine.
of both the respondents?
Yes.
Item number 2.
Lordship, this is a application for the appointment of arbitrator after setting aside of earlier arbitrator by this honorable court.
Okay.
That's why this application is for appointment of a fresh arbitrator.
Sorry?
Notice may be issued.
Lordship, notice is not required as per the 5-bench judgment of Supreme Court, Lordship. If if
But he has to
may
take
I-
instruction, he has to take
Lordship,
instruction,
Lordship.
he has to take instructions, isn't it? Whether whatever you have stated. Not, huh? Not clear. Okay. Now you can hear.
Lordship, yes.
Now, he has to take instructions as to what you have stated, isn't it?
Okay, Lord.
Because he has to respond to it. He
Lord.
may say no, nothing like that.
Yeah, Lord.
Okay. And Mr. G.D.
Dhiman,
Dhiman, petitioner in person. The present application has been filed for appointment of a fresh arbitrator in lieu of the earlier arbitrator.
on
How do
lieu
you-
of the other award
oth-
set aside,
Okay, the award has been set aside.
set aside.
Okay,
It is award dated 11/8/22, Lordship.
it was set aside on what ground?
Lordship.
No opportunity of hearing was given on that ground, it was set aside.
You have challenged the award.
I challenge the award before court, that is
Okay.
set aside, Lordship.
Okay. Infraction. Okay. After the award has been set aside. Issue notice returnable 3 weeks. Mr. Accepts notice on all the respondents,
All
I
the
think. you can, huh?
Lordship, may kindly be given a fixed date. I,
Date, yes, give a date.
in the last week of October, Lordship.
Last week of October.
Last
When do you want to tell us?
Any date, the
Last
week.
October will be 26th of October, 26th of October. 26th of October.
Lordship,
Okay.
obliged, Lord.
Obliged.
For admission, item number 3 to 5.
Lordship, our part has been already argued, Lordship, it was railways to reply, Lord.
Right. Is there any other matter which is non-hearing matter? No. Any other non-hearing matter? Non-hearing matter. We will not replace hearing by another hearing, but we may postpone hearing by another non-hearing matter. Any non-hearing matter? Huh? Sorry, we can't.
Again, a hearing matter,
Huh?
review application, my lord.
Review application, that has to be heard.
Because none of the petitioner is here on service. Very short.
But short or long hearing,
I think they only take next time.
we will see that. Any other matter which is not a hearing matter? No. And how long you are likely to continue? Mr.
Will take time.
Huh?
Will take time.
Will take time. Take time means what?
Today I'll take the entire time that's remaining.
You want to do it entire time.
Maybe it may not be over.
It may not be over also. And if it is not over today, then tomorrow it will be over.
Or if it is fixed,
Oh, tomorrow is not an okay.
there is no bench.
Oh, there is no bench because tomorrow, actually, the whole problem is that this last week is a motion day, no?
Right.
Huh?
If not otherwise inconvenient.
Because of that, all the lawyers also not ready for hearing. All are non-hearing matter, no?
Lordship.
No, if you can complete it, then but then again, if today you are not able to complete, then there is a problem.
It will take time, my lord, because lordship has taken the other side has taken 3 or 4 days.
But I remember that you will take only 15 minutes or 20 minutes.
For my submissions, but the judgments, my lord, it will take time.
Oh,
I'll
I
have to
see.
read out the judgment.
For judgments will take time, not your submission.
Submission I can finish within half an hour.
Half an hour. But reading out judgment will take time.
It will take
How many judgments you are going to cite?
at least minimum 2 from my side,
Minimum 2.
from my side and my learned friend.
But I thought you are relying only on the central, from where again you are adding another judgment.
TRF I would be relying on my.
TRF they have already explained,
I'll have to distinguish it.
distinguish. Only thing that if you can't finish today, because then again,
So for a central organization is concerned, I'll have to read out the entire judgment. It's a long, I'll have to read out.
why we have all read.
Probably he has not read the entire judgment. It has not been, central organization has not been placed, my lord, and that's my trump card. It has been placed, my lord.
Central organization have been read. That's what they are trying to say, that central is not applicable
Yes, lordship.
unless they have read.
Yeah, they've just made the submission, but it was not placed, I suppose, central, not read out before the honorable court. No, lordship, it has been placed.
And we have to read out judgment from top to bottom.
Because the,
Some, at least some
Huh?
person, some person, relevant person,
because
so that it's, squarely covers our case, and that judgment has taken care of the notification,
everything.
which is issued subsequently, and their claim is that it's, it was passed in sub-silent here.
Okay. Nico, then hard miss
Any of lordship.
and a counsel for the petition. Then we'll have to go to the next after vacation, because I thought if he's able to finish today, then
Yes,
it can be reserved. But then I can some thought, but then he can't finish it, then the problem will arise.
Lordship, immediately after the vacation, lordship, because
Immediately
it's been,
after-
it's been more than a year, I think. It's almost a year, almost a year.
But
Vacation period.
I was not for a year. I
No,
just came very.
It's for lordship, you
So.
almost a year. but The registration. Immediately.
It may have been pending, but
Yes, lordship, yes.
okay. Anyway, we'll, no, I have understood your case, They just want to explain it,
Lordship.
distinguish it, that's all, but I was under impression that he would be able to finish. But then he said he won't be able to finish, then we have to go the next after vacation. Hard miss, Lico petitioner, also Mr.
P. Sharma.
B. Sharma, who submits that he will not be able to conclude the argument today. Since it's the last day, before the vacation. Let the matter be listed immediately after vacation, immediately on after vacation. Yes, Mr. Sharma, when can we hear then?
26.
26 is a Wednesday, probably lordship is taking my arbitration matter on Wednesday.
Why not 19?
I can mail it.
Huh? Sorry? I can hear. There has to be two, please use the mic properly. Huh?
For item number 3 and 4, it
Huh?
will not be available on 19th.
17 to 22 is done.
Not available.
For treatment time.
Oh, for treatment. Okay.
26 is
Then 26. Then. Okay, yes.
Item 7.
Kandarpala. What is this Kandarpala? What is this?
This matter is
On the request of Mr. D. Bora, petitioner, matter stand adjourned. R. Sensua, Vishwakarma, somebody he is appearing. Mr. Vishwakarma.
my name is not reflected in the call list.
Huh? Sorry?
My name is not reflected in the call list.
But who is this Mr. Vishwakarma?
Lordship is senior counsel in this matter.
You are his junior counsel. Vishwakarma is your senior counsel. Okay. But what is Mr. D. Bora or Sensua? Petition Sensua. D. Bora. Are they here? No. No affidavit has been filed, received till date.
Mr. Lordship, MA Oasis,
Sorry?
MA Oasis.
Okay. You are for the petitioner?
Yes, sir, for the petitioner, we were supposed to file a reply for the affidavit on opposition.
Have you filed your affidavit in opposition?
No, Your
Vishwakarma, then Mr. T. Das, Mr. R. Chauhan. You are Mr. Chauhan. Mr. Chauhan. You have entered appearance in August. You have filed your Wakalanama. Have you filed your affidavit in opposition? You have filed.
We were supposed to file the reply. We were supposed to give the reply for the affidavit on opposition.
But where is the question? When did you file? When did you file? It's
We
not
were
here.
supposed to file today, Your Lordship.
No, their affidavit in opposition. When did you file?
Filed on 5th
Huh?
September. 5th of September.
6th of September. It's not here. This affidavit of opposition is not here. No? 6th of September. No? Not tagged. Okay, you have filed. Huh? Mr. R. Chauhan, Lana Counsel for the petitioner, respondent submits that he has filed the affidavit in opposition. However, the same is not on record. Ms. Oasis,
MA Oasis.
M. Oasis. Spelling, sorry.
MAM.A.OASIS.
Submits that she would like to respond, she would like to file a reply.
Sorry, Your Lordship, we won't be filing a reply today.
Acha, then what, when?
We won't be filing the reply.
You won't be
today.
filing. Okay. Okay. You have received a copy of the same affidavit in opposition?
Yes, we have received.
Okay, submit that she has received a copy of the affidavit in opposition, and according to the matter be listed for hearing on the next date. We can-
Can the date be fixed after the vacation?
Yes. तारीख तो दे दो.
Lordship, my
List
name,
again on, huh?
my name will be reflected in the call.
Huh, sorry?
My name shall be reflected in the call list.
Item number
7.
7. Okay. Vishwakarma T. Das is mentioned. Your name has been missed out. Okay. List is by showing the name of Mr. R. Chauhan, counsel for the respondent. Yes, next.
211.
Oblige, Your Lordship.
Supplementary list for admission, item 20.
Raitani, Padhad. Oh, right now Padhad, this similar thing, this one.
Yes.
These railways,
Railway.
the central.
Central.
So then it will come up then on that day. Padhad.
As per.
List on, since, list on
26
actually.
details, Lordship.
And Miss Jane Lanikant, also Goswami, release the matter. 26
2016.
on joint prayer, yes.
Item number 21.
Soham, what is this, was? This Soham for what?
Well, that matter hard, my lord, by your lordship, when the admission clause is there or not, my lord, they are challenging the admission clause. I
So
have to
today, what is to be done?
My
Today?
lord, they took time last time, my lord, that they will submit more, my lord. He had argued for some time. He had argued for some time and he wanted to submit more, my lord.
I just
The contract,
begin, but I'll need some time, Lord.
Okay.
Even today I'll need some time about.
Okay.
It comes as a number one item, single item and one day.
no, my lord, it's a long pending matter, my lord, and
Yeah.
my lord.
I'm ready.
It is
Not-
filed in January 22, my lord.
I'm ready, Lord.
Yes, for January.
That's what
My lord,
I think it's fair to.
In
mention.
fact, my lord, these matters are to be.
I can-
We
I
can
can-
argue, my lord, now time is there. my lord.
I can begin. No, begin, go. But minimum, I just fair to mention that it may take time.
No.
That's why I will say it.
Half an hour you take. You can please.
It will take the time.
Hmm?
I thought it's very fair to mention this, it will take time.
No, I'm not.
No, okay, it may take time, but,
Half an hour, my lord, he said me, my lord, it may take half an hour.
I don't know.
He said half an hour.
Yes, half an hour. You will conclude today.
No, Lord, I think I will read out some judgment. These are bunch of judgments I have to disprove. This is a heavy responsibility on me. I have to establish, he said, is a condition.
Problem is, Mr. See, if you can complete, then I have no problem. Then I
Well,
can
I
write. But
have
then if
been,
you can't complete, then the whole others are waiting
Well,
and so it will go on same.
Submitted written argument. He said on the written argument, he will submit more.
I
Correct, on the written.
have to explain certain things in the written. It will take time.
Let him explain, my lord. I think it.
I'm ready to do it, but just that I may not be able to finish it. That's my only.
My lord, initially, my lord, it says,
Yeah, I'm not-
no, this is not so.
You can begin.
Every time, my lord, time is taken. That's not.
I'm not taking time.
Anyway, then we'll on reopening what to do on, what about on 16 or 16?
I'm ready to begin, Lord.
19, sorry, 19 reopening. 19, because even holiday,
19, well, it has not been shown as a part, maybe shown as a part.
is not.
In the
Okay,
list, it is not.
okay, no, okay. And Mr. Sahiwala, counsel for the petition, also Mr. BJ Ghosh,
I'll go, sir.
R Goswami, sorry, R Goswami for the respondents. Who submits a removal out to submit on 16th November, October. List secondum 16 as part heard.
1910.
Well, part heard.
Can we take another single item or let's say? at the
Uh-huh,
top of the
sorry?
list? At top of the list, Lord.
See, I don't know what kind of things have been listed, so the top of the list, bottom of the list, it will be taken up, don't worry, everything will be
That will
taken.
ensure
So
some
now
time.
it was the last item, 21.
1910.
Alright.
On 19th. For orders,
Hmm.
daily list, item number 14.
Item number 14. Abdul Hamid. Wish for the yes.
Mr. K. Gogoi is conducting this case.
Who?
Mr. Kostov Gogoi, Lord.
Who Gogoi?
Mr. K. Gogoi, Kostov Gogoi. Lord.
Kostov.
My lord, I have some objection, my lord. Time and again, they are taking time in this case, my lord. This is a case, my lord, where, my lord, 4 of the petitioners approached the Honorable Court, my lord, from the same college. In other cases, my lord, Lordship has,
See, I
person-
understand, Mr. Saika, the problem is today, no, normally I would hear. But today, if you are not able to complete, then it will remain as a kind of,
I will take maximum 10 minutes, my time, my lord. I will take.
On our part, some.
but then Mr. Gogoi, I don't
Yes.
know, who is, see, earlier, I don't know.
The
This-
covered case by this Honorable Court.
Mr.
order.
A.S. Bhuya, standing counsel, present. Earlier it was A.S. Bhuya. Then R. Dhor.
Mr. K. Gogoi is now pursuing the matter.
See, who is the standing counsel for higher education?
I am also the standing council of higher education.
Who is Mr. A.S. Bhuya?
As we are is also.
So many standing counsel,
Yes, sir.
they'll come one time. So who is the standing counsel who will be standing for this case?
What about
Yes.
the
Appearing, standing and appearing for this
The
case.
only thing, my lord, the court petitioners approved the Honorable Court, my lord, this Honorable Court directed in case of 3 cases, my lord, consider their cases for provincialization in terms of 11 Act. Their cases has been provincial, my lord, being considered for provincialization under the 11 Act. My case, my lord, in this case, my lord, it was directed to consider my case under the 2018 Act. So, my lord, my case is being considered under the 18 Act. So, my lord, tendency of this review petition may not be barred to consider my case, my lord, under the 11 Act, my lord. That observation also may add, my lord, if time grant is allowed, my lord. Because from the same college, my lord, same schedule, my lord, 6 persons were not provincialized.
But this cannot be ground for reviewing of the order. So Lordship, we'll rely on some judgments also in this regard.
What is the order? Let us see the final order for direction of the court.
Yes, my lord.
Gogoi submits that a case so can be considered.
Yes. In terms of 2018 Act. Now they are seeking for to under 2011 Act.
But that would change the entire direction of the court.
Yes,
Earlier to consider your case under 2018.
yes, my lord.
And if you say that 2011 also, then it changes the character, no? It will be
My lord,
review.
in other cases, my lord, in the list, lawsuit, if you lawsuit see, my lord, there is the schedule, my lord. Schedule, my lord, this list, page 25, my lord. Page 25. My name is at my lord, second name, my lord, Abdul Hamid Khandakar. In other cases, my lord, lawsuit is granted, lawsuit, page 25, my lord. This is the non-teaching staff, my lord. I am one of the non-teaching staff, my lord. In the cases of other persons, my lord, it was directed to consider their cases, my lord, under the 11 Act.
You also non-teaching?
Yes, my lord. I'm
Other 3 persons also non-teaching?
non-teaching, my lord.
And they were appointed during the same time as you were appointed? Huh?
Same time, my lord, identical time. My lord.
Then why didn't you, this 2011, why didn't you ask for it at that time?
My lord, what happened?
Yes,
my lord?
Mr. Gogoi. He says, though the direction is to consider his case under 2018. He says that 3 similar cases where the government is going to consider under 11. Is it similar, whether I get or not? Huh?
We are going to consider it 2018 Lordship.
Their case also,
Lordship.
that 3 case also.
They have filed contempt also Lordship. It is under the process for consideration of 2018 Act. They are
Okay,
not eligible under 2011 Act.
those 3 also.
Lordship.
So therefore, there is no,
Lordship.
there is no disparity, huh?
Lordship. Lordship.
Same.
Lordship.
Yes. Then? Yeah, government is saying that we are not going to consider them under 2011. Huh?
They're considering.
Maintainable Lordship. How review is maintainable Lordship on that particular ground.
Anyway, if we'll see if there is another issue.
The recent communication, my lord. This is by the, my lord, additional secretary to the Government of Assam Higher Education Department, to the director, my lord. Proposal for creation of post of non-teaching staff of Hamidabad College. With reference to the subject cited above, I am directed to request you to kindly clarify and furnish the detailed report as to whether the petitioner's name were included against the public within the number of posts under the schedule of the Act of 2011.
You are asking some queries.
Yes, my lord.
It doesn't mean that they are going to be considered.
In cases of other petitioners, my lord.
2000 under 2018 Act proposal is sent to the government Lordship. It is pending Lordship.
That was written back.
It is pending.
That proposal was written back.
What is the difference between 11 and 18?
My lord, 18 Act, my lord, I will, my lord, I will not get the salary from, my lord, 2013. They will get the salary from 2013. There are
And
some-
11,
11 Act, my lord, from 1/1/2013, they will get the salary, my lord.
and if you are regularized under 18, you will not get a salary from 2013.
My lord,
It will be prospective.
prospective. 5 years of. service. my lord.
When their name was also not included that particular list at that time also. That particular act was also struck down in the meantime also.
What, or you can, what we can say is that you can consider, because that portion, whether it should be,
Yeah.
the benefit will be retrospective or can be considered,
That cannot be lost because lordship.
and that cannot be.
That because lordship 2018 act, 18 is a specific act for the gate 4 and gate 3 employees. Earlier 2011 act lordship, it is a combination of the lordship lecturers as well as lordship gate 3 and gate 4. Now lordship 2018 act is especially for the gate 3 and gate 4 staff.
And so so therefore his case is not covered.
No, no.
No, my lord, under the 11 Act, the lecturers were provincialized. Only the non-teaching staff of the college, my lord, were not
Then we have to
provincialized.
hear on merit then.
Yes,
have
my
to hear
lord,
on
you can
merit.
hear the case on merit, my lord.
But see, I don't know, had Mr. Chaudhary, petitioner, Gogoi, and so, considering the nature of the case, this could view the present can be disposed without issuing any formal notice to respondent. The petitioner initially joined service as a library assistant. Thereafter was upgraded. Usually, it is something those who are eligible for provincialization exam had not been done. It has been submitted to service of many who are eligible, not provincialized. They approached the court by filing various petitions and court directed consideration of the provincialization of such person. Mr. Gogoi submits that the case of petition can be considered in terms of 18. In view of the above, now this order was passed in your presence.
My lord, what happened, my lord, if I'm permitted, my lord, on that day, my lord, I was on legs in.
Oh,
court for
whatever the
my
one, Mr. R.
One of my-
Chaudhary,
one of my
Amar
colleague
Chaudhary.
came, my lord,
Huh?
he, my lord, sought for adjournment, my lord. My friend submitted that, my lord, this can be considered under the 18 Act. And my lord, accordingly, lordship, my lord, dispose of this petition, my lord. So, my lord,
Who is this Mr. Amar Chaudhary?
one of my colleague, my lord. Amar Chaudhary, my lord.
Okay, then we'll hear then. List the matter again on Sanko. Yes.
1611.
1611 my lord. আগত দিও বা পিছত দিও?
211.
Oblige, my lord.
Item number 15.
Oblige.
Sandhya Rani, yes, Mr. Pataniyar,
Yes, my lord. Petitioner has retired from service, my lord.
retired from service.
Yes, my lord. The order under review is direction is at page 97, my lord.
Hmm?
Page 97, my lord.
What is the order? Page?
Page 97.
87.
97.
97. Accordingly, this is disposed of directing respondents more particularly so and so to initiate a process filling of the said process principle of the said school and okay. Now he has retired.
Yes, ma'am.
But the problem is this, after retirement, that the order, if the order stands, there will be difficulty on our part to get pension, all these things, because Honorable Court, your lordship was pleased to, earlier 3 cases were allowed, and suppressing those matters, the private respondent has filed the petition and took a final order. And that order was reviewed by lordship initially, and that order is there, my lord. And that review application now, if
So after this order was passed, what happened?
now after, if the review, my lord, is allowed
No. Okay, this order was passed on 3/1/2020.
by lordship.
After that, what happened? Because this case was filed by Chandrakanta Goswami.
Goswami.
Who is this Chandrakanta Goswami?
That Goswami, their lawyer,
Huh?
I informed, he is not attending the court last, that also on the last day.
No, Mr. Shaikarang review Terang P. Education present. Goswami is not present. C. Goswami is not present today. Earlier, Mr. Goswami led a council list the matter again on 2/5.
Yes,
So today, where is Mr. C. Goswami? His name is shown.
he is not seen, my lord.
No, his name is shown in the cause list. C. Goswami is there. Why he is not coming?
No, my lord, his cause list is, his name is there, my lord.
But why he is not coming?
That I do not know, my lord, with respect. Once upon a time, he was my junior for more than 10 years. I advised him that you attend the court. And on that day also I told him. He is, why he did not attend, I do not know.
So your junior is not listening to your advice.
So the case may order may be taken up after vacation. Because I don't want to disturb him. He was a very humble senior once upon a time. Only problem is this, the review application, if it is finally allowed, then I have no objection. Because your lordship was pleased to stay the earlier order passed by your lordship. Suppressing the material facts, 3 judgments passed by this court. They have filed the reparation. That was.
Yes, Mr.
I
Khotaniya.
don't think so, Malab, this order will harm him, Malab. Because there is a direction to
Huh.
filling out the post of principal of said school, Malab.
Correct. What happened after this? After this order was passed, what happened? Was it filled up?
That instruction I don't have, my lord, but.
You know, you must be knowing what has happened to that.
That order, my lord, when the order was passed to fill up the post, prior to that, the High Court stayed. Because there was.
So who is holding the post now?
There was not the SMC, managing committee. So on that ground, Honorable Justice Mullah Guru has stayed that earlier, in earlier petition, stayed the proceedings for appointment.
That
And they
was,
suppress it. Suppress
Anyway,
it.
what is the position right now?
Now, my lord, I am retired already.
Correct. Who is the principal now?
Now, my lord, in charge is the in charge principal. I
In-charge
have no
principal.
objection. If the
In-charge
post-
principal, not Sandhya Rani.
Yes, I'm retired.
Okay, and Chandrakanta Goswami, where is Chandra?
He retired in 2017,
He also retired.
but he was disturbing us all the time.
this is the writ appeal against that order, my lord.
He was collecting the
Subsequently,
money.
the review petitioner was allowed to hold the charge of in-charge principal, my lord.
Review petitioner means
Sandhya Rani, my lord.
Sandhya Rani. Then
She was allowed to, by this order of this honorable division, my lord, she was allowed to hold the charge of in-charge principal.
Huh.
Though the petitioner shall continue to hold in-charge principal of Bezara Secondary School, but she shall not take any major financial and administrative decision except the day-to-day matter and as to draw and disburse the salary, etc. of the teachers of staff of so-and-so school.
so the Sandhya Rani was allowed to function
Yes, my lord. Till
No.
her retirement.
till her
Yes, my
retirement.
lord.
Then you regularize her pension. Then what is the problem?
Yes.
My lord, I don't think so, my lord, her pension, is there any difficulty in their pension, my lord?
Uh,
I'll to that
See,
extent, I'll put the
see,
instruction, my lord.
now, obviously she can't be asked to be appointed on regular basis
Exactly, my lord.
because she has retired by this time.
Exactly, my lord.
And she is also not interested to work anymore.
Exactly.
Only she feels that now that she is retired, she should get the retirement benefit
Yes,
attached to the post of that principal,
as the principal in charge.
in charge.
That entirely a different cause of action, my lord. This is not in this review petition, my lord. This cannot be a cause of action, my lord, regarding her pension, my lord. If she is
Correct,
not
correct.
getting
No,
pension, my lord,
correct. Pencil is a consequential effect of what he has been
Exactly.
doing at a
Exactly,
time.
my
Huh?
lord. But the order under review is regarding, my lord, initiation of a regular
Because
selection for
because
post of
according to
principal.
her, if she had been regularly appointed, and then obviously the natural consequence will flow that she will get all the benefits. But now because of this, you have not complied with, according to. So what to do now?
I think this order
Yes, if
can be reviewed, my lord.
If they give me all benefits as a principal in charge of the
Principal in charge, my lord.
senior school and my pension, then my review petition can be closed.
That itself a different cause of action, my lord. That cannot be clubbed with this review, my lord, because here direction was issued to hold a regular selection process, my lord. In the meantime, she was allowed to hold the insurance principal. This was affirmed by the honorable division bench, my lord. And in the meantime, she has
Then we
retired, my lord.
can close with the observation. Then it may not be necessary to review this order, but in view of the subsequent development which had taken place, if she had retired from that post
Yeah.
on in charge basis, the government will do the needful, all the benefits, consequential benefits
Yes.
attached to that post.
Yes,
We can close it. Otherwise, why keep this matter pending like
That
this?
I understand, but
So we'll not review this order.
Yes.
We'll
But-
not review this order, but
Yes.
we'll make an observation. We'll make an observation.
that I understand, but that is not his prayer in the review petition, my lord.
Correct. But then what is the point? The idea is to close this because otherwise, see, they will.
My
We
lord,
can,
then
we
close
can
it.
close. That's why we are not changing this. We are not reviewing this order as such. We can make an observation.
Even
Then we can make an observation in the
Yes.
meantime because of subsequent development which has taken place.
yes,
It may not be necessary to review this order. However, he will make a representation and the government will do the needful. You submit a representation,
All the consequent benefits
benefit, the government will
released, ma'am.
consider granting all the benefits.
and should be released within a specified time. Because they are taking the plea, the review case is pending, and otherwise the review.
Okay,
doesn't
Liko,
allow-
Liko, we'll let us close it, then there is no
Yes,
point,
sir.
because,
Otherwise, I have no option, but.
correct,
but-
correct. We have understood you, we are not changing the order, we are not
but
reviewing the
that
order.
Direction may lead to another litigation, my lord.
No, no, it's not a question of direction, because after all, she is entitled to certain benefits. You decide,
Obviously,
you decide it,
Yes,
that's why I will
obviously.
give it. Huh? On Mr. R.C. Saikia Learned Council for the review petitioner, are also Mr. Khatunia.
For my lord, 1, 2, 3. 1, 2, and 3, my lord.
For the one, for 1, 2,
And 3, my lord.
1, 3. Full stop. However, none appears for the respondent number
4, my lord.
4, oblique writ petitioner, though the name of the council of the respondent number 4 is reflected in the course list.
Yes.
On earlier occasion also, respondent number 4, the council, learned council for respondent 4 remain absent. In this review petition, the petitioner is seeking for a review of the order dated 3/1/2020 passed by this court in WPC number 9570 of 2019. The said order was passed. The said order passed relates to the appointment, regular appointment to the post of principal of which senior secondary school of
Bezera, my lord.
Bezara-
Bezera
of
Ansolik-
Bezera Anchalik Senior Secondary School,
Yes,
comma Bezera Kamrup. From the order, it appears that the said post had remained unfilled on regular basis, had remained unfilled on regular basis. And in that context, this court disposed of the said writ petition with the following direction, page 97. Accordingly, this writ petition disposed of by directing respondent number so and so, to initiate. Thus,
Yes.
it has been submitted at the bar that it is submitted by Mr. R.C. Saikia, Learned Council for the review petitioner, who was the respondent number 4 in the said writ petition, that the said order was obtained by the writ petitioner Chandrakanta Goswami by suppressing certain facts. What was the fact she has suppressed this Chandrakanta Goswami?
My lord, he suppressing the earlier judgments. He moved the petition for fill up the post of principal. And my lord, when these earlier judgments were suppressed and your lordship passed the order to fill up the post by the government, then I filed this review application. Because in earlier judgments,
By
it was suspended. That the appointment of the principal was suspended. That I have filed explicitly.
by suppressing certain facts.
Yes, ma'am.
However, during the pendency of this, during the pendency of the review petition,
My lord.
it has been submitted by Mr. R.C. Saikia that though the said writ petition was disposed of in the aforesaid manner, the present review petitioner, that is, who was the respondent number 4 in the said writ petition WPC number 9570 of 2019, was allowed to hold a charge of principal on a charge of was hold the post of principal on in charge basis.
Good.
And because of the litigation between the present review petitioner and the aforesaid Writ petitioner Chandrakanta Goswami, respondent number 4 in the present review petition.
Yes.
The process for regular appointment to the post of direct principal could not be completed. In the meantime, the present review petitioner also retired from service on attaining the age of superannuation.
Yes.
However, as in charge principal of the said senior secondary school, without her being considered for regular promotion, regular appointment to the post of principal. Since the present review petitioner, who was the respondent number 4 in the said in the WPC number 9570 of 2019, has already retired from service, in your opinion, in the opinion of this court, reviewing the order dated 3/1/2020 in WPC number 9570 of 2019 as quoted above, may not be necessary. Inasmuch as the present review petitioner cannot get any, cannot be considered for regular appointment to the post of principal at this stage. And as such, this court is the view that the question of reviewing, the plea for reviewing the said order at 3/1/2020 passed in WPC numbers 9570 of 2019 does not arise. However, even though this court has held that the review, under the circumstances, the review petition may not lie any longer, yet the fact remains that the review petitioner, the fact, learned counsel for the review petitioner submits that though she had retired from service as principal in charge, she had not been getting any retired or pensionary benefit.
And consequential benefits.
And other consequential retired benefit, the pension and other consequential retired benefit. This is in respect, this got the view that the authorities can certainly consider, for which the review petitioner will file necessary application before the concerned authority,
It was
before the
submitted-
competent
it was
authority.
sub- It was submitted already. Petition is submitted. now.
Submitted, which can be considered by authority. Mr. R.C. Sarkar submits that the petitioner, review petitioner has already submitted an application on, when did you submit?
File after, just after retirement.
Oh, date.
Date I can't remember, but
Arey.
they say this 2 months ago.
And you must keep a record that on this day, how they will consider, because there are thousands and thousands of applications.
No, this, she retired on
Oh,
January.
what, how they will reply, or you file a fresh.
No, all right, man.
In the, and however, the petitioner will file a fresh application
Yes.
with a copy of this order, copy of the order passed by this court today,
Yes.
claiming pension and other retired benefits for the service rendered by her, including as principal in charge
Yes.
of the said senior secondary school.
Yeah, ma'am.
And the authorities will do the needful as expeditiously as possible, do the needful payment of the pension and the other retired benefits as per rules,
Yes.
as expeditious as possible, preferably within a period of
6 months, madam.
6 months.
Yes, madam.
What 6 months?
My lord, I don't know the stage, my lord, whether. Pessoa has
I
been processed
retired
or
in the
not.
month of January.
3 months. 3
It
months.
is now, it is 9 months.
3 months. 3 months. Within a period of 3 months. From the receipt of a is from 3 months from the receipt of the representation that may be submitted by the review petition as directed above.
My lord.
With the above observation, the present review petition stands closed.
Obliged. Obliged.
Item number 16.
Item number 16. What is this? Review petition. This is also review petition. Yes. Tell us, you have 15 minutes, 12 minutes left.
Lordship, sometime will require. Lordship.
Will require.
I am in a hurry.
You are in a hurry.
Because salary not paid. And-
Why you are not, why you pay a salary?
No, Lordship, the issue is that the person was working as a project engineer. He was terminated from service. Termination was interfered by this honorable court, directing to hold an inquiry. And his appointment was completely contractual. Lordship, subsequently inquiry was held, and again he was terminated. But the termination order did not reflect about the entitlement from the date of the last order of this honorable court interfering in the termination order till his reinstatement. And Lordship directed that under FR 54A his entitlement should be considered. But Lordship, while passing that order, it was not brought to the notice of this honorable court that already an order was passed. That is the fact.
Okay, already order was passed denying him
Yes, Lordship, and-
pay for that period.
Yes, Lordship.
On the ground that no work, no pay or
Yes.
something like that.
My
Huh?
lord,
Yes.
I see.
my contention is that they have 3 times passed the order, withdrawn that, no pay, no work. After that,
Okay.
my lord, what happened? This court has given at least 8 or 9 times, you place it, whatever you pass, and ultimately this honorable court has passed the order. In writ court, they have not placed it, if anything, and they have not confirmed whether this reached to the petitioner or
And
not.
Lordship,
That is
subsequently,
another
he has
question.
challenged the termination order
And
also.
Lordship
That
has
is
directed whether it reaches. But thing is that, my lord, the termination simpliciter, there is a agreement clause that 1 month salary should be paid. That was also not paid. So according the termination also interpret 2 ground, my lord. One is this termination simpliciter and some stigma is put on this head without any inquiry. So your lordship has rightly passed the order and they have not placed it. Last in affidavit, I have brought all these orders. They have not placed it in their petition, my lord.
How much is the amount which is to be required to be paid? If you are, if suppose, how much is claiming? How many crores?
Lordship, no, the total amount he has not stated, Lordship.
How much you are entitled
My
to
lord,
get?
18/2/2012, he was removed with some as termination simpliciter. It interfered in 2016, my lord. After that, he was deemed to be in service as per honorable court's order, and he was joined also. After that, they started the inquiry. After 3 months, they said there's no DP.
So how much you think you will get?
My lord, if at that point of time his salary is 30,000 or 40,000, my lord, it was 40 months or 30 months, my lord, like that.
How much is that?
5-6 lakhs, my lord.
5-6 lakh.
My lord, he's still not without any pay, my lord, and he's.
What is the direction of this court, please? Which you are seeking to
Lordship,
review, yes.
page 22.
Huh?
Page 22.
22.
Relevant
And
paragraph
uh-huh.
5.
5. And no order was passed with this court after initial order of termination dated which was set aside by this court. Further, the authority also not stated anything about the same when the final order was passed on so and so terminating petition from service. And since the matter of termination was set aside by the court, we were required to examine payment of salary under FR 54A2. This court also taken into consideration submission made by so and so that the substantial allowance of the bidder would be paid after he makes a proper application along with the certificate of non-employment, which is according You have got the subsistence allowance?
That was also, that is their contention, that you give me non-employment certificate, we'll pay something, but that was also not a penny, not a single penny.
Accruing responsibility will pass over for payment areas, so and so, so and so, so. But at least subsistence allowance,
Lordship,
once he is reinstated in service and the inquiry goes on, then he is back in service.
Lordship, he was getting salary, full salary, after reinstatement, Lordship.
No, that period. That period, when he was out of service, once that termination order is set aside, it will be deemed to be under suspension, no?
But Lordship, the order did not reflected anything, and Lordship, he was never subsequently, Lordship, at page 134, we brought to the notice of this honorable court that he was not present. Then court directed that he will be paid as and when he.
Okay, then we'll hear, but then we'll dispose it after vacation, huh? Puja
Yes.
vacation, huh? After puja vacation, to try to do
211.
on joint prayer, Mr.
Item number 18 and 19.
What is this, Bijoy Shankar Thakur?
I am praying for accommodation today. I have already prepared an affidavit. I sent it for vetting, my lord.
Okay,
will
Mr.
file it in the-
Patonier, Lanet Standing Council for
Secondary education, my lord.
secondary, he wants to file an affidavit prepared.
But in the meantime, I am not getting any benefit, my interim benefit, my lord, paying from provisional pension, my lord.
And pension, you can get any
No, my
problem
lord, issue is totally different, my lord.
in a sense.
My lord, initially he was appointed, my lord. My lord was pleased to interfere with his appointment, my lord. Subsequently, the respondent in the review petition was appointed, my lord. So in the meantime, he died, my lord.
Oh,
Now he is not in service, my lord. Practically, he is not in service, my lord. So if he is not in service, the pension cannot be paid.
how will you get pension unless you have rendered service?
On merit, I am this, let the matter be decided on merit.
Okay. And Mr. B. Purkasto Lane Council for the review petitioner.
Review petitioner.
Yeah, for a review petitioner. Also, Mr. B. Purkasto, who prays for how long?
Uh,
2 weeks
2
to
weeks,
file the
yes, my lord.
affidavit of position.
Affidavit of position, my lord.
Okay. Least second after vacation.